Sir. Hello. Saidi Iqbal sir. Hello. I was at page 231 of volume 2.4.
Volume 2.4.
Internal 2 of my written submission. Since my lord already
Yes.
had my written submission, internal
Your
page 2.
submission start 230.
Lordship, please.
You are on 231.
Lordship, please.
Yes.
Now, minutes. Excommunication is distinct from the main practice at issue in the review petitions. It is being explained here briefly for a comprehensive understanding of the issues. It is a form of social and religious boycott with permanent effects on the excommunicated person and their family. It is ordered by the Dai-ul-Mutlaq, the head of the Dawoodi Bohra community, in response to any action he deems a violation of his wishes. A full description of excommunication has been provided in writ petition number so-and-so with specific illustrations of its impact. Now, my lords, I take my lords to volume 3.4, page 72.
Volume?
Volume 3.4, page 72. This is a commission appointed by the then Citizens for Democracy Millets, an organization founded in the wake millets of the Gujarat agitation and the emergency that followed. It had an eminent composition. It is headed, millets. The composition is important only for this reason. If your lordships have the composition. N.P. Nathwani, MP. Mr. N.P. Nathwani is a retired judge of the Bombay High Court who subsequently became a Lok Sabha MP. Prominent again, millets, for his defense of civil liberties. Mr. V.M. Tarkunde needs no introduction to this honorable court. Dr. Alam Khanmiri and Dr. Moin Shakir were prominent academics of the Marathwada University and the Osmania University. And Mr. C.T. Daru, the Solicitor General will bear me out, millets, was a respected and prominent civil liberties advocate of Gujarat millets in the 70s. It is this commission which labored over 2 years and traveled to various cities to document instances. One of the questions put to me was, what were you doing till 1986? The very fear of excommunication prevents people from speaking up. Mr. Siddharth Luthra is going to follow me in female genital mutilation. Why is that issue coming up now? Because for the community, even to protest against this cruel practice of female genital mutilation, invites fear of reprisal. Therefore, these are the circumstances under which this tiny community under the leadership of the Dai functions. Now I come straight, to 5. The fear of excommunication prevents people from speaking up. Now I come back, to just 5 instances your lordship will find as part of the Nathwani Commission report, which is annexed to the writ petition. Page 152. The lordships of governments, and I'm giving only 5 instances, that's all. (152) internal, page 76. Middle minutes. If all my lords have located minutes, Justice Bagchi has got it minutes, and this Mahadevan has got.
Yes.
It's on the screen, minutes. In the middle minutes, it's on the screen. Breaking up of marriage is a very familiar method. Ibrahim Ali of Udaipur has given pathetic examples of his family, his sisters and other members who suffered because of the break of their marriages under compulsion. His only fault was that with the cooperation of all friends from other communities, he had started a cooperative bank in Udaipur without the permission of the Sayedna's agent. His sister, Dr. Khadija, who was a professor in Baroda Medical College, was tragically divorced with 2 children. Sheikh Ahmad Ali Qurban Hussain Rajnagarwala suffered most because of the forced divorces of his two daughters, so and so and so and so. One of his daughters was divorced when she was pregnant, and the shock of divorce made her lose her child. Then so and so of Taj had her marriage broken in 1975, and her brother's wife deserted him. Because, Millets, the print is not clear. They were forced to divorce because of the whole family suffers, Millets, social ostracism. So the wife can't live in society because she is married to an excommunicated man. These are the effects of excommunication, Millets. Now let me go to the second instance straight away, Millets. 158. 138 Millets. Now this is about an election. In fact, I should start from bottom of page 137. Last paragraph, Millets. Mrs. Mehfooza so-and-so, aged about 30, of Udaipur, has stated before us that her husband is a social reformer from the very beginning and that he is working for the spread of education in the community and the uplift of the poor. He has organized an institution called Safi Imdadia for helping male and female students by giving scholarships, books, etc., and also a dispensary for giving free medical treatment to sick persons. After the defeat of those candidates whose names had been sanctioned by the Sayadna at the municipal elections in Udaipur in 1970, the Sayadna was displeased with her husband and she became the first victim of his wrath in the incident at Galiakot, a place 75 miles from the town of Udaipur. There is a dargah at Galiakot where Bora pilgrims congregate in large numbers at the time of the Urs Mullets. What happened there may be described in her own words. She describes, Millets, I'm not going to read the whole thing, somewhere in the middle. In the middle, then they started saying that I, this lady Millets, was an enemy of the Dai. They further said that they will outrage my modesty. I was asked to condemn my husband because he's a kafir. The next page. Then next one. Then page Millets 139. One Mrs. Safia Bai, widow of late Mohammad Hussain Delhiwala of Udaipur. Yeah.
They asked me to.
Yes, but when she, just one line I have to read from the previous minutes, I'll just speak it out. Minutes. When she declined to condemn her husband as a kafir, one individual rushed towards me and dealt a lathi blow on my head. Now, minutes, page 139.
We understand. See, these are all instances you bring it out.
Only 5 minutes.
We take it because then whether these pay incidents of social factors in a particular religion, in a particular occasion, community, would that give the promoter to the court to exercise the power, as Mr. Sir has put it, and 25(2)(b. Is the issue now we take it. See, for example, let us say sati or something like that. We can go for the worst case than this. So therefore, we understand what is it about. Then you can formulate your
I will not read out any more instances. So the broad instances would be
yes, all right.
breakup of marriage,
Yes.
loss of employment, complete social ostracism, and most important, if you are excommunicated, you can neither go to the mosque nor can you be buried in the community's graveyard. Therefore, an individual's 25(1) right is taken away. The only reason for giving these instances,
Custom, see, mired in the exploitation and arbitrary exercise. But question for us is to how far we can go into this and which way you approach this.
yes,
You
that
come
will
to
be
the
part of
court,
my submissions.
Or you can approach the government. If they don't do it, then you can come back and then ask us to look into it. These are the factors we can say.
Yesterday we told you, now the act has been repealed.
I'm coming to all that.
Provision Act which was upheld by this court, if that act is repealed,
Few occurrences here.
Then what happens?
Jurisdiction.
5 judges of this honorable court in this very matter, which have placed this matter before this honorable court, have dealt with the fact of repeal of the act. When I come to that, I'm going to place that order, the referring order, which is an order of about 36 paragraphs, which deals extensively with all these issues. So I'll place that. The purpose, I will stop with my
What is the
instances.
situation in the community? Is the excommunication still going on?
Yes, that is the problem.
Then what should be done?
That's right.
In such a situation?
All that I'm saying today is when your lordships are dealing with this 25-26 interplay, it is not just temple worship. If Mr. Khambata hadn't mentioned the fact of a Parsi woman's deemed conversion, if Mr. Siddharth Luthra is not going to mention the fact that there's female genital mutation, your lordships will be deciding this question as a purely academic exercise, which can't be mirrors. To that extent, therefore, it is important to tell your lordships, why were we
can't-
sent here, mirrors?
We can't interpret or we can't understand the true import of 25 and 26 in abstract.
Yes.
There has to be some little factual scenario background in which these questions will ultimately arise for our consideration.
Lordship, please.
You are referring these facts only for that limited.
Yes, mirrors.
You are not asking us to adjudicate these individual instances,
Not at all.
permissible, impermissible.
That is not before 9 judges. That is not before 9 judges.
You understand?
And so are other issues not before 9 judges, which I am going to say in the end.
Yes.
Now,
Therefore, don't labor much on these things. We take note of it. See, whatever material you brought to our notice, we take note of it. We take this as a sample.
Lordship,
No problem.
that
And
was
we
the
can
only intention.
read this and then go to the.
I go
limitation.
straight.
That's it better.
I go straight. Now, let's kindly come to para 3.2, volume 2.4, which is my written submission, which is where I started from. I only went to give illustrations.
3.2.
At
Yes.
page 231, paragraph 3.2.
Yes, the practice of.
The practice of excommunication has been prohibited by the state twice. First, the Bombay Prevention of Excommunication Act 1949, and second, the Maharashtra Protection of People from Social Boycott, Prevention and Prohibition and Prohibition and Redressal Act 2016. The
Mr.
90
Chandran, the 2016 Act has not been challenged.
It has not been challenged. It is here, but it is what the 5-judge bench has recorded is that even if the 2016 Act is there, the question of the validity of the practice of excommunication will survive. And the Solicitor General has also made his submission before the 5-judge bench. When I read that out, that question has to be squarely dealt with, because whether that act is challenged or not, this judgment stands. If this judgment stands, 1962 judgment, then the 2016 Act will also be bad, whether someone challenges it or not.
It is all right.
Yeah.
We've-
Now, I'd given briefly the judicial history of this in my opening yesterday. I referred to the fact,
Volume 2, is it?
volume 2 minutes,
There
volume
cannot-
2.4.
There cannot be a deemed ultra virus.
No, the-
Legislation cannot be deemed to be ultra virus.
Lordships are not being asked to declare anything as ultra virus.
No, we are not declaring. You are pleading before us that the excommunication survives because 2016 Act will be deemed to be ultra virus in view of the observations made inside.
Let me place it in the language of this court, which is more elegant than my language, minutes. How the 5 judges who sent this matter to 9 judges has viewed this very issue of the 2016 Act. I can't put it better than how the 5 judges have put it, and I'm going to place that before your lordships.
2.3.
Now, minutes,
2.3, volume number 2.
2.4.
2.4 minutes, which is my written submission.
2.4, page 231.
But that, are we answering that reference?
You-
Whether 2016 Act can survive the observations of a 19.
That is one of the questions before the 5 judges.
Yes, but that reference.
Then the 5 judges, while recording why the question would still survive, still hold that some of the questions involved.
need a clarification. Are we answering the 5-judge reference? We are
No.
answering a 9-judge.
Your lordships are
reference.
answering the 9-judge reference.
Whatever we hold with regard to the interplay of 26
You will go
in
back.
relation to 25(2) will have its impact on
On-
the 5-judge reference.
Lordship, please, let me go back there. All that the
That's-
5 judges
that's-
say is, all that the 5 judges say
So
is,
we are limited to see whether excommunication, even if it is held as a matter of religion under 26B, can survive in spite of social reformist legislation like the 2016.
grateful, Mirs. I'm grateful, Mirs. That is all, Mirs.
So we need not go into the question whether Article 32 is challenging the 1962 judgment.
I'm obliged. Mirs.
Because that's water under the bridge.
40 years.
No, it's water under the
Lordship,
bridge.
please, and
that-
5 judges have said that the judgment might require reconsideration.
That is in 1986.
Now,
Yes, now.
the 2023 judgment of 5 judges, which places the matter before your lordships, also expresses doubts on Sardar Syedna, on the 1962 judgment, saying that so much law has developed since the 62 judgment. Therefore, Mirs,
So your argument before us is while interpreting 26B in relation to 25(2)B, we should declare the 1962 judgment as not good law. That's
yes, Mirs. Yes,
irrespective of its binding nature,
Lordship,
etc.
Lordship, please. Yes, Mirs. And that question will necessarily come up when I read the reference order. Your Lordship will see how this court has articulated it. Now, Mirs, 3.3, I'm not going to read out fully because I had briefly summarized the history, which is this. Privy Council declares that the Sayadna has the power to excommunicate. Immediately, the Bombay legislature in 1949 passes this act. This act comes up for consideration in a proper list between an excommunicated person and the Sayadna. Both the single judge and the division bench
Bombay High Court.
hold that the act will cover and that the act is constitutional. 49 Act. The
19-
Sayadna then brings an appeal to this court against, for convenience of reference, I say the Chief Justice Chagla division bench judgment. That appeal doesn't proceed on technical grounds because of death of one of the original plaintiffs. Then the Sayadna files an Article 32 petition in respect of that very act, which has been upheld by the division bench of the High Court and has therefore, in a sense, become final after the appeal before this honorable court fails. Now the Sayadna brings a direct 32 petition and makes only the state of Maharashtra a party. So while the validity of the act was tested by the Bombay High Court in the context of a list between parties, between an excommunicated person, the Sayadna and the state, the 1962 judgment is a judgment rendered in a 32 petition between the Sayadna and the state of Maharashtra. Can we now ask in 2026, why didn't the Supreme Court, while adjudicating this very important question and while being aware that the Bombay High Court had upheld it in the context of a list, why didn't this honorable court ask parties, members of the Dawoodi Bohra community, to be implemented here in a representative capacity because they have a vital say? No, all that has gone.
No, Article 32 petition was filed by Sayadna to say that his Article 25(1) and Article 26 rights were violated vis-a-vis the state law. State law came under Article 25(2).
Absolutely.
So he said that is violation of those two rights. So it is only against the state legislature, against the state.
It can't be.
Question of hearing the.
I'm sorry, my lords.
objection
If in a list,
that community.
I'm talking about fairness.
the act was brought
Yes,
for the protection of certain rights of a particular community.
community.
That community was a direct stakeholder.
And it was not
They should
invaded.
have been heard. The probably prima facie, the manner in which the writ petition was entertained is probably questionable.
Lordship, please, my lords. Therefore, if you have to find fault, we'll start finding fault from there. So therefore, my lords, let us concentrate on the questions of law here, my lords. That is my submission. Now, my lords, I come straight to the issue-wise submissions.
No, no. His right as a guy under 25(1) to propagate and under 26(2) as a denomination was ultra-virus, was rather vitiated. Therefore, he challenged against the state.
Only he and he alone, his subjects didn't matter because they were his slaves.
That is
I'm
not-
sorry.
We are not commenting on that, but he had the right to test the validity of it.
Of course, he had the right, my lords.
Could have gone under 226, but he came under 32.
No, before right was to be determined by this court. He had only locus to come,
Lordship.
and in that locus, he should have, in all fairness,
Lordship,
impeded
please.
those who were directly the stakeholders and directly likely to be affected by the outcome of.
I'm grateful, my lords. Would your lordships have page? Would your lordships have page 232, internal page 3 of my written submission?
Yes.
Because I'm
Yes.
coming straight now to my issue-wise submission. I'm
Yes,
not going
please.
into any facts, my lords. One, issue number 1. What is the scope and ambit of the right to freedom of religion under Article 25 of the Constitution? And, my lords, I assure my lords that where I'm agreeing with Mr. Khambata or with Ms. Jai Singh, I will say they have said so. Only if there's something additional, I will say. The preamble secures to all citizens liberty of thought, expression, belief, faith, and worship. A specific expression of liberty of belief, faith, and worship is in Article 25. When the preamble refers to fraternity, it takes care to secure the dignity of the individual. Fraternity assuring the dignity of the individual. Therefore, my lords, the right to freedom 1.2 of religion is primarily the right of the individual under Article 25(1). All persons are equally entitled. Then, Article 26 is an expression of the fundamental right to freedom of religion. Here, my lords, Justice Sundaresh has already, my lords, made observations that Article 26 is nothing but an extension of Article 25. And my lords, Mr. Khambata,
Here, before this court.
in the writ petition,
Who is this Central Board of Dawoodi
it is
Forum?
a registered society. It is a registered society registered with the Bombay Charity Commissioner. There was a petitioner number.
I made a respondent in this case.
Yes, yes.
Who is representing him?
Mr. Neeraj Kaul, who created the initial mischief.
You're going by the earlier judgment in support of your
Yes.
rights.
Yes.
They are community
Confounded
of individuals.
Mr.
Yes,
Ramchandran, you have confounded that confusion. 86, it was done. Who prevented you from not filing a review petition?
Yes.
A review petition in which matter? Can I ask with respect?
Shahidna's matter.
I'm not a party.
You could have sought the leave of the court.
I could have done many things, my lord. So many things could have been done in retrospect.
40 years.
I am sorry, my lords, with the utmost respect. This question was put yesterday also, and let me try to
We'll put
answer
it
it.
tomorrow also.
See,
The question of Justice Arvind Kumar is,
a community of certain individuals of this community have come up before this court.
a registered body of this, along with, at the time of filing of the petition, Mr. Asghar Ali, engineer, a victim of excommunication and violence, was the second petitioner. himself a victim, was the second petitioner. In 40
You are
years,
all conformist to this Dawoodi Bohra religion, or you are not?
we are Dawoodi Bohras. We are,
Are you conformists of that religion,
of
or
course,
are you not?
we are conformists, but we cannot be slaves. And if
The
we are
whole
bound,
question now.
if we are bound by the medieval oath,
The question now.
if we are
Yes.
bound by the
The
medieval
issue
oath,
is entirely different. They are a community in whose protection the legislature intervened, which was duly protected under 25(2). That's protection has been taken away through a judicial mandate. So that's why they are here before us.
Lordship, please.
Legislation was in
Right
general,
now
not
only we
only
are
our
not on the
community.
point. Right now, we are not on the point. We are only on the point that
For all
they-
communities.
their case is completely different than the other cases, because here there was a law protected under 25(2) in their favor. That law has been intervened by this court, maybe for good reason, maybe for bad reason. And that's why the different kind of situation here.
And let me answer Justice Arvind Kumar Millets as best as I can. What were you doing till 1986 was the question yesterday. That is the question today. Another question is, why didn't you file a review petition? One, I was not a party. A third party review may or may not be entertained. All this is in the realm of speculation. Secondly, the very fear of excommunication includes the fear of approaching court. This is, my lords, the nature of the hold. Therefore, there is no sudden with the utmost respect. With the utmost respect, there is no sudden. Generations of persons have suffered excommunication and humiliation. They have been humiliated and died.
Go to
It
Supreme Court.
takes,
Go to
it
Supreme
takes
Court.
courage. It takes courage to approach court.
Still continues in your submission.
It continues.
Fear of exclusion, fear of social ostracism, fear of exclusion, which may as good as a civil death to a person. still
Complete
continues.
civil death.
Still
Exactly.
continues.
And I can't be told in a matter of Article 21,
Cause of action arose, you should have approached the civil court.
Millets, fundamental rights, this is not CPC, Millets. This is Article 21. There is no waiver of Article 21. Here are families who have suffered indignity. And we are told, or we are asked, you should have filed third-party review. I couldn't have filed curative because curative hadn't come at that time. Therefore, Millets, 40 years after this writ petition has been entertained by this honorable court and has gone through the gamut and has come here. Again, when a 5-judge bench tells me come and assist the 9-judge bench because 2 questions are common, again and again for me to have to come back and say, what were you doing? That will be the last part of my submission. I repeat again, Millets, I don't, with the utmost respect, wish to further address on this issue until I complete my propositions.
You want to put this again.
Yes.
Tomorrow, a group of individuals of your community can come and ask, come and tell the court, please restore excommunication.
Then,
Why should this court indulge into all this? They may say, we want, it is part of our religion, our Sayadna's rights are violated. We want excommunication in our community. Now, what should this court answer? Can it go on giving answers to individual groups of your religion?
I'm sorry, Millets, with the utmost
This
respect.
is not the argument from your side. This is not the relief you are asking for.
It is
You are
not,
asking
Millets.
for, there was a law in your favor. 1949 Act was there. You were very much happy with the act.
Lordship,
That act, when the constitution came into force, was duly protected, being an existing law
Lordship, please.
under 25(2).
Grateful.
And therefore, you had no occasion to come to the court. You had no occasion to raise any issue. This law is struck down by this court,
Lordship.
and that creates the problem.
Lordship, please. And
And
therefore,
besides
I
that-
should be permitted to proceed with my
And
submission.
today, Mr. Raju, in fact, state you could come to the your first argument probably.
Yes, ma'am.
Subject to, of course, we are again not going to disturb you. We will hear the manner you want. That there was a law, existing law, when on duly squarely to be protected under 25(2), being an existing law. This court therefore should not have interfered, because that law had the protection of all those parameters which are provided in 25(2). Nevertheless, it was interfered we were not heard.
Got you, please.
Today, there is another statute of 2016. If it is inadequate, the law should be interpreted, it should be read down in such a manner that the protection of 1949 is restored.
Got you, please.
Or if it is adequate enough, then that law should be protected. This court should not interfere in the existing law. That is what
That is my
probably
submission.
your entire case.
Lordship, please, minutes. And
And besides that, Mr. Raju, it's a continuing cause of action.
completely continuing cause of action.
Estoppel or a limitation in that.
Absolutely, minutes. If there's no
You are
waiver of fundamental rights,
Into the rights, in fact.
if can be no waiver of fundamental rights as in a Katina of cases, and if this court is the protector of fundamental rights, the sentinel on the key weave, then it is only this court that I can come to. Now may I proceed, Mullets, and
Yes,
come back to that issue at the end, Mullets. Now, Mullets, 1.3. Article 26 is an expression of the fundamental right to the freedom of religion in Article 25. Here, Mullets. No, I don't. Page 232, Mullets, bottom.
Yes, yes.
You are at 1.3?
1.3 minutes. Internal, page 3. Article 26 is an admission of the fundamental right to freedom of, is an expression of the fundamental right to freedom of religion in Article 25. The Constitution recognizes that persons in exercise of their Article 25(1) right, 1.3, page 232, bottom, volume 2.4. My submissions, Bills. It's on the screen also. Article 26 is an expression of the fundamental right to freedom of religion in Article 25. The Constitution recognizes that persons in exercise of their Article 25(1) right have formed and continue to form denominations for the organization of their religious activities. Article 26 protects such expression of the beliefs, doctrines, etc., which are fundamentally protected by Article 25(1) and consequently must be subject to the limitations therein. Article 26 does not grant denominations extraordinary status relative to individuals under Article 25(1). As Justice Sundaresh observed when Mr. Khambata was arguing minutes, 26 is nothing but an extension of 25. And I am not going to take my lords in detail through these propositions because I wholly endorse and adopt the submissions of Mr. Khambata that Article 26 is an expression of the 25 right in collectivity and that it does not have extraordinary status. And as Mr. Khambata put it admirably with respect to him, 25 can stand alone, even if 26 was not there. But 26 could not have stood alone if 25 was not there. That explains the continuum, the scheme of 25, 26 and further minutes. That is my submission as far as this is concerned, minutes.
Now, are you saying that your right under Article 25(1) is violated?
It is because by being excommunicated by my community, I am not able to follow my religion, which includes going to the mosque of my community, participating in religious occasions of my community, and finally, when I go to meet my maker, to be buried in the graveyard of my community. So this excommunication is not just social, it is religious. So my 25(1), this is one of those cases, Millards, where 25(1) right of an individual is sought to be extinguished by the head of a collectivity.
So what is the right of the community under 26B then?
The right of the community under 26B to manage its affairs has to be,
We'll reframe that question. What is the right of other individuals under 25(1)? Now, that's what Kamata also argued. It cannot, can it go horizontally in this case? 25(1) is subject to certain restrictions, limitations. It is against the entire world, where the religious practice and belief. But you being a part, that's what Mr. Sisa also, you being a part of a denomination, religious denomination, can you assert your right over in trying within the denomination? That is not available. Now you have to demonstrate whether
I'm
such
coming
a
to
right,
that in issue
such a
two.
right is available to 25(1). If it is not available, what will be the other right you can have?
That is squarely answered when I come to issue number 2. That is squarely answered when I come to issue number 2. So if I may proceed in the sequence minutes,
Yes.
that is where I am.
Mr. Ramchandran,
Lordship, please.
your specific grievance is with regard to excommunication, right? Are you challenging the entire gambit and scope of excommunication, or you're limiting it to facets which are not religious? I'll give you an example. That the communicant can say that it's a denomination of the Shia, Islam, Shia, and then the denomination of that is Dawoodi Bohras. Then it can say that because you chose to associate yourself with the Dawoodi Bohras, religiously the Dai is the head and Dai have to follow in religious matters. But the moment the excommunication has the effect that nobody can meet you, nobody can do business, your social rights, your right to attend function, that cannot be done under the garb of, or are you saying the entire excommunication as a whole lock, stock and barrel should go?
I'm obliged, Lords. I'm obliged, Lords. That is the submission. And one step further, of course, if I am a Dawoodi Bohra, I have to accept that the Dai is the head of the community. I can't say there has to be a collegium of elders in place of the Dai. No, the Dai is the head. And as I gave my lords the example of the Sikh community yesterday, some amount of religious disciplining may be necessary to keep the followers of a religion together. But even if the trigger is religious, so therefore, I'm giving your lordships 2 examples where the Dai may exercise his power. One is starting a magazine without his permission. The second could be not obeying some religious diktat of his. Even the punishment for not obeying a religious diktat, because the first one, according to me, should not present difficulty, because it is purely secular, outside the scope of protection. Even when the trigger is religious, if the consequence is disproportionate in the secular sphere, not one day's cleaning of utensils in the Gurdwara, as may happen in the Sikh faith, or minding shoes for that day. But if the consequence of a religious disobedience diktat is disproportionate, having effect on my right to dignity under Article 21, then my submission is that even if the trigger is religious, the punishment has to be proportionate. And if it's a violation of Article 21, the court would intervene.
What happens to the right under Article 26B of the denomination?
That right has to be in conformity with the submissions already made. If 26B, as Mr. Khambata has submitted, is not to be read in isolation, it has been argued as to why the fact that there is no additional subjection in 26 as there is in 25, it is immaterial because it is part of a scheme Therefore, the 26B right cannot in any circumstances extend to the extent to which my constitutional rights, especially my right to life, liberty, and equality, the same golden triangle, these are completely non-negotiable.
This is very,
See.
very important.
The reason why this court struck down that prevention, the Constitution bench reasoned that it was a violation of the right of the denomination under 26B. Therefore, it was struck down. And the Dai came to this court, I as the head, who is the propagator of that religion, my right to manage my own affairs in matters of religion has been vitiated by this Bombay legislation. Therefore, he challenged it, recognizing his right not only under 25(1) second part, but also 26B. It was held that the Bombay legislation had made an inroad into these two rights, and therefore this court struck it down.
Correct. Now, let's just
Now,
two.
another group of individuals are saying, no, that striking down is bad.
Correct. 2 days back, only 2 days back, I remember my lady Justice Nagaratna telling one of the counsel here, why don't you read the dissenting judgment in some case minutes? Because there is much light from dissenting judgments. I am going to show in the course of my submissions that in the 76-year history of this court, 5 great dissents have become the law of the land subsequently.
But what is binding is the majority judgment, not the
What is
dissenting.
before 9 judges, what is before 9 judges is both the majority judgment and also the great dissent which is being commended for acceptance. And my submission is going to be that when I read Justice Sinha's judgment and read his reasoning, then your lordships will appreciate what that majority has completely missed. And therefore, there are some high constitutional moments in a court where a court corrects its error. It has happened 5 or 6 times. This I am going to submit.
Should tell us why this majority judgment was wrong,
I'm going to show that.
holding that Article 26B right in that case had to be upheld, and therefore the Bombay legislature could not make an inroad into that right. That is the reasoning.
When I try to persuade my lords that the dissenting judgment is right, obviously I have to simultaneously persuade my lords that the majority judgment was wrong. That is part of my submission. Now, let's.
Mr. Ramchandran,
Yes.
you have formulated that even if the triggering point is religion, but then you come to the proportionality. Is that not a tentatively, is that not an extreme view which probably cannot be reconciled with Article 26 for the reason that the moment it is an offshoot, even a slight color or tinge of religion in it, then who decides the proportionality? Proportionality, the moment it is a religious, any facet, even 1% hint of a religious smell coming out from it, then it has to be totally left in the discretion. Because it is a denomination, it has to govern itself in its own way. We cannot import as a court, then it will become redundant. So very correct that it can be segregated. To what extent the limitation of the effect of excommunication. You may have a point, but then you say, when you say that no, even if it has a religious figure, still probably that tentatively you'll have to satisfy us.
I
extreme-
appreciate the anxiety behind the question.
That extreme.
I appreciate the anxiety.
The question is whether the act of excommunication, is it a secular act or is it a religious act?
Irrespective of the nature of the act, my answer is this.
Please answer first
Yes.
this. Is it a secular act
It can be a religious.
associated with a religious practice, or it is a religious act?
Answer is
Oh,
clear.
no. Let us reframe it.
Yes.
you can also attempt to argue that whether the basis of excommunication is secular or religious.
Yes.
The moment the excommunication is based on a secular aspect, then probably you have a challenge. The moment it is based on a religious aspect, then probably tentatively the constitution will intervene.
That question is
And this court applied 26B.
I see the great anxiety behind the question.
And then the offshoot would be that even if it is religious, okay, to what extent the excommunication and to what limit would be the sphere of the excommunication.
That's my submission. That is my submission. I am not saying, milords, that this court will apply proportionality in the way in which your lordship may, in a service matter, say this should not have been dismissal, it should have been reduction in rank or stoppage of increment. No, it is only in cases where a court is satisfied that a person's right to life is being taken away. That way, my lords, 1 day's punishment in a Gurdwara is also an indignity in one sense from that person's point of view. I am talking of the total impact on a person's life, not 1 day's punishment.
So I'll use an analogy. What is being said that under the garb of power under 26, the religion cannot be turned into a hollow. Under the garb of excommunication, the individual cannot be made a hollow, like he remains.
Right. Grateful,
To
milords.
that extent, the individual has to be individual in the sense a living human being is required to be.
Lordship. I'm grateful, milords. Now, milords, endorsing and adopting Mr. Kambata's submission, I come to 1.4, bottom of page 234. The right to freedom of religion does not include a right to practice anything which infringes an individual's fundamental right to liberty, dignity, or equality, or which is contrary to public health, order, or morality. And then I give a reference to Milords Adityan's case. I'm not going to read the judgment. But here, in 2002, 40 years after Justice B.P. Sinha's judgment, Milords, this court again uses the expressions dignity, decency, etc. Milords, in the context of, Milords, the appointment of a non-Malayala Brahmin. Then, Milords, Adi Saiva, 1.4.2. Constitutional conformity, legitimacy. I'm going to come back to this on the fourth head of constitutional morality. Ultimately, therefore, is something consistent with the spirit or the ethos of the Constitution or not? No amount of protection can go to that extent that the ethos is here and this protection is in this watertight compartment, the ethos be damned. It can't be, Milords. Then, Milords, 1.5. Anything which is mainly secular is beyond the protection of Article 25 and 26. And that is what, Milords, Shirur Mutt also says. And then, in answer to Justice Amanullah's question, I think 1.5.2 would be.
Why did you say mainly secular? You can say secular, not mainly, anything secular.
Lordship, please.
They even go to the exam saying, which is associated with religious practice also.
Yes.
It goes, they much expanded interpretation is given. This element of secularism will be the secular act.
I bow to that also. I bow to my Lordship's saying.
Yes.
1.5.2 may perhaps answer Justice Amanullah's question. If the practice has a technically secular impact, but does not infringe any other fundamental right, it may not require any intervention. However, if the practice has a significant secular impact, infringing a fundamental right, it should not be considered a religious practice under Article 25 or a matter of religion under Article 26. Then, if the practice has a religious impact, that is, if it affects an individual right to religious freedom under Article 25(1), it must be balanced against that right. the impact of a religious practice cannot in all cases be a permanent infringement of the right to religious freedom. Therefore, the impact of a religious practice, including my spiritual head's disciplining powers, cannot be a permanent infringement on my right to religious freedom and, of course, on my secular life. And then, minutes, I've already 1.5.4 is covered by the example of the Sikh community, which I have given, minutes. Now, minutes, 1.5.5. This is the essence of the dissent of Chief Justice B.P. Sinha in Sardar Sayedna, which idea later finds expression in cases recognizing and protecting the rights to liberty, dignity, and equality, starting from R.C. Cooper through Maneka Gandhi. And once I say the submissions of dignity in response to issue 3 are relied upon here. And this is the appropriate constitutional moment for this Honorable Court to adopt this reasoning in deciding the relationship between Article 25 and 26 and the rest of Part 3. Some of the great dissents which were later affirmed as correct position in law are set out in para so and so. Therefore, a practice which is conducted in response to secular and social actions of an individual or which has significant secular and social consequences for that individual cannot be the subject of constitutional protection under Article 25 and consequently cannot be a matter of religion under Article 26. The scope, 1.6 is important, Millets. I read with emphasis. The scope of the right is shaped by the limitations in the Constitution. Harmful and regressive practices, and I'm talking of a completely regressive, retrograde, inhuman, and medieval practice, which perpetuate indignity and inequality, can be prohibited either by law or by the court in a dispute brought before it. This submission is expanded in response to issue number 2 on the interplay of 25 and 26. And Miller's, in the facts of excommunication without prejudice to the future determination of the issues and writ petition so and so, it is submitted that the practice of barat or excommunication is not a matter of religion under Article 26. The practice has to be examined from the point of view of impact. If the consequence of the practice is secular, affecting the non-religious aspect of a person's life, they are not limited merely to exclusion from religious activity or practice. They include civil, economic, and social consequences, the breaking up of marriages, the separation of close family members, closure of institutions, prohibition from entering burial sites. This is not incidental but deliberate. The excommunication is meant to have a devastating impact on the lives of the victims. Examples of excommunication I have given words. And then even if the trigger for excommunication, I think I've already argued that, I don't have to read this out again. Then those examples of triggers for excommunication 1.7.3, I've already dealt with in the opening part of my submission. So my conclusion on issue number 1, what is the scope and ambit of the right to freedom of religion under Article 25? I've summarized. The petitioner / applicant seeks to persuade this court to hold 1. A practice which is conducted in response to secular and social actions of an individual or which has significant secular and social consequences for that individual cannot be the subject of constitutional protection under Article 25 and consequently cannot be a matter of religion under Article 26. 1.8.2. A practice which may have a religious impact but also significantly and adversely impacts fundamental rights is not immune to restriction under Article 25 or 26. 1.8.3, it is the impact of the practice which must be considered by the court and not simply the stated basis, either historical or religious, to determine the extent of permissible restrictions. Then I go straight to...
Therefore, a person belonging to a particular religious denomination which you are representing, he is questioning a practice. Can that be, adjudicated upon in an Article 32 petition?
If it involves fundamental rights, it can be, is my answer. For your lordship's consideration. Now, issue number 2. What is the interplay between the rights of persons under Article 25 of the Constitution and rights of religious denomination under Article 26 of the Constitution? It is submitted that there are 3.
Everybody will start questioning the certain religious practices or matters of religion in a, before a constitutional court, then what happens to this civilization where religion is so intimately connected with the Indian society? There will be hundreds of petitions questioning this right, that right, opening
is where-
temple, closure of the temple,
In other
religious
words-
right.
In
We are
other
very,
words,
very conscious of this.
see, if you, what a sister is putting you is clear, it happens. Every religion will break, every constitutional court will have to be closed, because ultimately what you are seeking now before us, it is your belief and your practice, or even the injury that emanates out of it, whatever nomenclature you can say, it's a human right violation, whatever, but that's only consequence. Vis-a-vis the right of the another one or group of persons, which may be in the name of, in the form of a religious denomination, as you right said, it may be a form. It's maybe a structure you can give. Now, if this dispute between two entities are allowed to be, see now, like you read the dissenting chief justice now.
Not yet read, but
See what is regressive, what cannot be acceptable, what is excessive. These are all relative terms. Now, everybody will question everything. Yeah, then to allow that, then and see, maybe see they are not an instrumentality of the state. Now, it is more like an in-house this setup, where you want to say what you are doing is wrong. In your case, you may have a civil wrong be committed to you. In other case, another member will say, I don't agree with this. This is regressive. The other person will say that this is absolutely obnoxious. Now, what extent we can go into these aspects now in a country like ours, it is progressive and it is on the move. If we undertake this process, especially when consciously legislator has given this extraordinary power
Yes.
to be used sparingly by the state under 25(2)(b), in the guise of the fundamental violation of fundamental right, bringing your right under 25(1) as against the other right in 25(1). We'll be mixing up too many things.
can I give a response now?
We can-
If-
Please, you can give a response. I would like to add to my learned brother's views. What is unique about India as compared to any other region? See, we are a civilization. Why are we a civilization? Despite having so many pluralities and diversity, I said diversity is our strength. We are still a civilization, despite you may call a sovereign democratic republic, we continue. There is a constant. One of the constants in our Indian society is the relationship of human beings, man, woman, or child, with religion. It is so intimate to everybody. Now, how a religious practice or a matter of religion is questioned, where it is questioned, why it is questioned, whether it can be questioned, whether it has to be a question within the denomination for a reform, or whether the state will have to do it, or you want the court to adjudicate upon all these aspects. This is troubling us. See, we 9 judges, what we lay down is for a civilization. That is India. India must progress despite all its development, economy, everything. There is a constant in us. We can't break that constant. That is what is troubling us.
Now may I respond? Yes.
Yes.
Let us hear Mr. Raju also for some time.
If the same thought is being expressed, I think the time has come for me to attempt a response. Apart from the fact that I have answered it later, I'm answering it now only so that it doesn't appear that I'm ducking a question. We are a civilization under a constitution. And therefore, nothing which goes against the grain of our constitution can be countenanced in a civilized society which is governed by the Constitution. And it requires judicial statesmanship. That's where the task of the courts, the very difficult task of the courts come in. And there the courts can't throw up their hands and say, otherwise we'll have so many petitions. No, it is then the duty and the responsibility of the court to see whether there is a clear violation of fundamental rights which calls for this court's protection, or whether it is a mere difference between members of a religion which is not of that order which calls for the protection of a constitutional court, is ultimately for this court's wisdom and statesmanship. But this does not mean that there can be a judicial hands-off, because in my humble and respectful submission, there will be
understood that.
abdication. Now, may I go to issue number 2? What is the interplay between the rights of persons?
Page 239.
Yes, Mills. Now, this interplay is of 3 kinds, Mills. The interplay between an individual's right to freedom of religion under Article 25(1) and the rights of a denomination under Article 26. Second, the interplay between the rights of a denomination under Article 26 and the power of the state to enact legislation for social welfare and reform under 25(2)(b), notwithstanding the right to freedom of religion. And 3, the interplay between the subjection clause in Article 25(1), which makes the right to freedom of religion subject to the other provisions of Part 3, and the rights under Article 26. This is really the subject of issue number 3. But it involves an aspect of interplay, so I put it here also, but will be dealt with there. Now, minutes. Sub-issue 1, the interplay between an individual's right to freedom of religion under Article 25(1) and the rights of a denomination under Article 26. It is submitted that the individual's right under 25(1) cannot be subordinated to the denominational right under 26. As stated in answer to issue number 1, the right in Article 25 is the basis of the right to religion, specific aspects of which are protected under Article 26. There is no hierarchy of rights in the Constitution. If at all, the individual is at the heart of the Constitution, which is concerned with protection of the individual's dignity, equality, and liberty, and promoting fraternity between individuals. Reliance is placed upon the detailed submissions in respect of dignity in response to issue number 3. The right to religious freedom under Article 25 is subject to other provisions in Part 3, and therefore reflects the implicit principle that equality, liberty, and dignity cannot be undone by religious tenets. 2.4 is important. I am reading with emphasis. To lay down any rule which favors a religious denomination's right above this right would be contradictory to the ideals of the Constitution, which are focused on the individual. This court has never declared that a denominational right should be consistently favored over an individual right to religion. And it is submitted that such an extreme proposition should not be laid down in the present reference. This would seriously prejudice the Article 25(1) fundamental right to freedom of religion of an individual, regardless of the facts of their case and the degree to which the denomination seeks to infringe their right. Then, minutes. In a case where a denomination seeks to deny the right of an individual to practice their faith, it will become necessary to examine first whether the denomination's claim is at all protected by Article 26 or whether it is not, in fact, a matter of religion. Only if it is established that it is a matter of religion must there be an examination of the specifics of how and to what extent the individual is seeking to practice their religion, how and to what extent the denomination seeks to prohibit or control the individual's right, and the consequent impact on other fundamental rights. It is submitted that even when there has been a law under Article 25(2)(b), which restricts a denominational practice under Article 26(b), this court has correctly interpreted the law under 25(2)(b) to be in furtherance of some other fundamental right, including the right of worship. 2.5.1. It is submitted that the majority judgment in Sardar Sayedna requires reconsideration on this point, and the minority opinion of Sinha's Chief Justice must be held to be the correct interpretation of Article 25(1) and the correct approach to the question. The minority opinion of Justice Sinha gives a clear and precise view of the scope of Article 25(1), even within a religious denomination, and the nature of restrictions on that right. And his lordship says, minutes, and I'm reading out 2 or 3 paragraphs from here. It is noteworthy that the right guaranteed by Article 25 is an individual right as distinguished from the right of an organized body like a religious denomination or any section thereof dealt with by Article 26. Hence, every member of the community has the right, so long as he does not in any way interfere with the corresponding rights of others to profess, practice, and propagate his religion, and everyone is guaranteed his freedom of conscience. The question naturally arises, can an individual be compelled to have a particular belief on pain of a penalty like excommunication? One is entitled to believe or not to believe a particular tenet, or to follow or not to follow a particular practice in matters of religion. No one, therefore, can be compelled against his own judgment and belief to hold any particular creed or follow a set of religious practices. The Constitution has left every person free in the matter of his relation to his Creator if he believes in one. It is thus clear that a person is left completely free to worship God according to the dictates of his conscience, and that his right to worship as he pleases is unfettered so long as it does not come into conflict with any restraints, as aforesaid, imposed by the state in the interest of public order. A person is not liable to answer for the verity of his religious views, and he cannot be questioned as to his religious beliefs by the state or by any other person. Thus, though his religious beliefs are entirely his own, and his freedom to hold these beliefs is absolute, he has not the absolute right to act in any way he pleases in exercise of his religious beliefs. He has been guaranteed the right to practice and propagate his religion, subject to the limitations aforesaid. His right to practice his religion must also be subject to the criminal laws of the country, validly passed with reference to actions which the legislature has declared to be of penal nature. Laws made by a competent legislature in the interest of public order and the like, restricting religious practices, would come within the regulating power of the state. For example, there may be religious practices of sacrifice of human being, etc. I won't read out that whole sentence. It is open to the state to intervene by legislation to restrict or to regulate to the extent of completely stopping such deleterious practices. It must therefore be held that though the freedom of conscience is guaranteed to every individual so that he may hold any beliefs he likes, his actions in pursuance of those beliefs may be liable to restrictions in the interests of the community at large, as may be determined by common consent, that is to say, by a competent legislature. It was on such humanitarian grounds and for the purpose of social reform that so-called religious practices like immolating a widow at the pyre of her deceased husband, or of dedicating a virgin girl of tender years to a god to function as a devadasi, or of ostracizing a person from all social contacts and religious communion on account of his having eaten forbidden food or taboo, were stopped by legislation. Therefore, the quotation ends with, therefore, it is clear that even where a restriction on the right to religious freedom is based on the interest of the community, such restrictions must be in consonance with secular interests, that is, the equality, dignity, and right to life, not the interests of the religious community. It follows, and this is important, that Article 25(1) protects an individual's right to freedom of religion against any denominational practice which would penalize such individuals through measures which violate the Constitution. That is, a denomination cannot claim that the only options available to an individual are to either voluntarily leave the denomination or to be subjected to such practice. Such a position is not compatible with the freedom of religion envisaged under the Constitution. Religious denominations may have the right to persuade their members to follow certain practices, but they are not permitted to coerce people into following those practices on pain of a penalty like excommunication, which violates the Constitution. In Sardar Sayedna, the argument was raised that excommunication was purely a matter of religion and therefore protected by Article 26B against any interference. Justice Sinha rejected the contention that it was a purely religious matter. His opinion contains a prescient understanding of individual dignity in the context of the Constitution and the object of the 1949 Act, which sought to prohibit excommunication. he examined the practice and impact of excommunication and correctly understood that it is in fact both religious and social boycott. He held, it has been further contended that any person who has been excommunicated as a result of his non-conformity to religious practices is not entitled to use the communal mosque or the communal burial ground or other communal property, thus showing that for all practical purposes, he was no more to be treated as a member of the community and is thus an outcast. Another result of excommunication is that no other member of the community can have any contact, social or religious, with the person who has been excommunicated. All that is true, but the act is intended to do away with all that mischief of treating a human being as a pariah and of depriving him of his human dignity and his right to follow the dictates of his own conscience, long before dignity was actually read into the Article 21 words. The act is thus aimed at fulfillment of the individual liberty of conscience guaranteed by Article 25(1) of the Constitution and not in derogation of the Constitution. I will stop here minutes. Then we'll kindly come to the bottom underlined portion. On the social aspect of excommunication, one is inclined to think that the position of an excommunicated person becomes that of an untouchable in his community, and if that is so, the act in declaring such practices to be void has only carried out the strict injunction of Article 17 of the Constitution, by which untouchability has been abolished, and its practice in any form forbidden. That's just one facet of the reasoning, Mills. It's not based on Article 17. The article further provides that the enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. The act in this sense is its logical corollary and must therefore be upheld. The majority in Sardar Sayedna, that is the majority opinion of Justice K.C. Dasgupta, and the concurring opinion, Millets, of Justice Rajagopal Iyengar, did not even consider the contention that by prohibiting a religious and social boycott, the 1949 Act was protecting both the religious right of the individual under Article 25(1) and the secular rights under social boycott, against social boycott. Therefore, it is submitted that the majority judgment in Sardar Sayedna does not lay down that a denominational right will override an individual right to freedom of religion, where there's a conflict between them. Conclusion on sub-issue 1 and issue number 1 on the interplay bills. The petitioner seeks to persuade this court to hold 2.6.1. The right of an individual under 25(1) cannot be subordinated to the denominational right under Article 26 as a general rule. 2.6.2. Article 25(1) protects an individual's right to freedom of religion against any denominational practice which would penalize such an individual through measures which violate the Constitution. Then it's sub-issue 2 in issue 2, which is the interplay between the rights of a denomination under Article 26 and the power of the state to enact legislation for social welfare and reform under Article 25(2)(b), notwithstanding the right to freedom of religion. 2.7. The rights under Article 26(b) must be harmonized with the provisions of Article 25(2)(b) if both are to be given effect, and the law under 25(2)(b) can restrict religious practice. This is, of course, subject to the observation of the learned Chief Justice yesterday, minutes, that harmonizing, if it has to be harmonized, if there is a clash which requires harmonizing. Then 2.8. A law under 25(2)(b) can restrict religious practices. Article 25(2)(b) enables restrictions on religious practices if warranted, for social welfare and reform. If there are questionable practices and dogmas which stand in the way of the social welfare and progress of the country as a whole, there is scope for legislation intended at liberal and progressive reform. Such law, 2.8.1, would always be subject to judicial scrutiny to ensure that it meets the test of proportionality to the extent that it curtails a fundamental right, and the courts will examine inter alia the object of and sustainability of or necessity or impact of the law, necessity for and impact of the law. Once there is a finding that the practice alleged to be infringed is in fact related to a matter of religion, the test of proportionality can be applied to determine the validity of the law curtailing the practice. if it is found that the curtailment of the fundamental right is disproportionate to the actual advancement of social welfare or reform through the law, the court may then harmoniously construe the law under 26(2)(b) along with the fundamental right. The appropriate balance to be struck in this process of harmonious construction would only be determinable on a case-by-case basis. Then, Millards, there is an extract from Devaru, Millards, and the harmonizing principle, which I am not going to read out, Millards. And then, Millards, 2.10 minutes at page 19. Before Devaru, the unanimous 7-judge bench in Shirur Math had also recognized that 25(2)(b) permits restrictions on religious practices after relying, Millards, on that famous Australian case, Millards. And then, Millards, 2.11 in Sayedna Tahir Saifuddin, Bombay High Court, the Chagla Division Bench, Millards, upheld the constitutional validity of the Bombay Prevention of Excommunication Act, holding inter alia that the 49 Act was a valid exercise of power under 25(2)(b) for the purpose of social reform, and that the practice of excommunication is not protected by Article 25 or 26 of the Constitution. This judgment was set aside by a majority of 4 judges of the Supreme Court in Sardar Sayedna, and it is submitted that the judgment in Sardar Sayedna was incorrect on this count. Then, Millards, there is an extract from Chief Justice Chagla's judgment, which I do not need to read out, Millards, except the underlined portion, Millards, para 20. Therefore, in passing, my lords have got that, Millards?
Yes.
Therefore, in passing that act, what the legislature has done is for the removal of the disabilities of the Harijans, it has created a new offense. Similarly, here, the object that the legislature had was social reform, and the social reform contemplated was to prevent the practice of throwing people out of their community and depriving them of their rights and privileges. And here, as in the Harijan Act, the legislature has created a new offense by Section 4, by penalizing all those who do any act which amounts to or in furtherance of communication of any member of that community. Then, Millards, 2.12. It is submitted that if at all there is any dispute, it should be, if at all there is any dispute as to whether a law under Article 25(2)(b) can prohibit a religious practice, reference may be made to the material indicating that the drafters of the Constitution intended for social reform to counter certain religious practices. So there was never any hands-off, and deliberately introduced a provision which is now 25(2)(b) to permit such reform. And there is some new material which I have cited, which will be useful. 2.12.1. After the Fundamental Rights Subcommittee, which was a subcommittee of the main Advisory Committee on Fundamental Rights, completed its draft report on the right to freedom of religion, concerns were raised that social reform may be blocked by wide scope of the draft right and the inclusion of the word practice in the freedom of religion. This is recorded in the framing of India's Constitution, a study that is B. Shivarau's, Millards. 2.12.2. Sir Alladi Krishnaswamy Iyer's concern that without a specific saving for social reform laws, the freedom of religion clause would override such laws are also recorded in a separate note. He wrote, "It may stand in the way of all social legislation and strike at legislation already passed, having regard to the wide language as to the effect of any deviation from the fundamental right guaranteed." This is Millards, part of this book, Millards, Beef Shivarau's select documents, Millards. In the light of these concerns, the deliberate decision was taken to expressly protect the state's power to enact social welfare and reform measures, notwithstanding any religious practice, in the understanding that if it was not there, the basic tenets of certain religions could be so bad as to militate against the ideals of a civilized society. In that context, Article 25(2)(b) was included in the Constitution. And last, page 252, internal page 23 of my note, Millards. The chairman, Sardar Vallabhbhai Patel, in this context, Mirrors, entrusted the task of drafting such a provision to Rajagopalachari and Shyama Prasad Mukherjee. This is important because this task with regard to 25(2)(b was entrusted to two great leaders who were known as conservatives. On the basis of their recommendation, the committee decided to add to the clause a new explanation providing that the freedom of religious practice would not debar the state from enacting laws for the purpose of social welfare and reform. Therefore, Millets, it is therefore clear that a law under 25(2)(b is intended to and must necessarily touch upon a religious practice.
Paragraph?
2.13, 2.13.
Yes.
The meaning of social reform cannot be restricted to exclude religious practice. When there is a conflict between religious practice and the need for social reform, religion must yield. As Dr. Ambedkar explained in the Constituent Assembly debates, the conception of religion in our country is so vast as to cover every aspect of life from birth to death. Precisely, Manoj. If the state were to accept the conception of religion and give it primacy, if the state were to accept this conception of religion and give it primacy, the country would come to a standstill in regard to reform. Then, Manoj, there is an error in Justice Iyengar's concurring opinion, Sardar Sayedna, which I have highlighted here in this one paragraph. Let me read out. The 2.14.1. The concurring opinion of Justice Iyengar in Sardar Sayedna interpreted a restriction in Article 25(2)(b, which does not exist and which would defeat the purpose of social welfare and reforms. The concurring opinion holds that such law under 25(2)(b could not affect practices which are a basic part of the religion, but can only affect practices associated with religion. In his reading, Justice Iyengar wrongly conflates the subject of Article 25(2)(a with the subject of 25(2)(b, which is an incorrect reading of the articles. This error in Sardar Sayedna was noted by Justice Nariman in Sabarimala as contrary to the exposition of law in Shirur Math. Nariman J, however, left this issue open to be decided in some future case, since this was the view of only one judge and the point was not directly in issue. Therefore, Mirz, the conclusion on sub-issue 2 in issue 1 is the interplay between the rights of a denomination under the conclusion is here, 2.15. The petitioner applicant seeks to persuade this court to hold 1. Laws under 25(2)(b can curtail religious practices if necessary to advance social welfare and reform. Such law would always be subject to judicial scrutiny to ensure that it meets the test of proportionality to the extent it curtails a fundamental right, and the courts will examine inter alia the object of suitability of necessity for and impact of the law. 2.15.2. Once there is a finding that the practice alleged to be infringed is in fact related to a matter of religion, the test of proportionality can be applied to determine the validity of the law curtailing the practice. 2.15.3. If it is found that the curtailment of the fundamental right is disproportionate to the actual advancement of social welfare or social reform through the law under challenge, the court may then harmoniously construe the law under 25(2)(b along with the fundamental right. The appropriate balance to be struck in the process of harmonious construction would only be determinable on a case-by-case basis. Then, Minutes, issue number 3. Whether the rights of a religious denomination under Article 26 of the Constitution are subject to provisions of Part 3 of the Constitution apart from public order, morality, or health. Now, Minutes, I am not going to read these submissions in detail for the reason that Mr. Khambata's submission that these can't be read in silos has, my lords, made the point sufficiently clear. So the same thing I don't want to say, only in slightly different words, my lords. So I come straight, my lords, to the conclusion, except to say that if dignity of the individual is the centerpiece, then automatically the conclusion will follow, my lords. There's a reference, my lords, in 3.4 to the constitutional philosophy embodied in 14, 19, and 21, the Minerva Mills Golden Triangle. And then 3.5, the fundamental rights contained in Part 3 of the Constitution are not watertight compartments. All these rights have to be read harmoniously to give meaning and effect to each of them. And this was, if I've understood correctly, the thrust of the learned Solicitor General's balanced and moderate submission, minutes. Then minutes 3.8. 3.8. It is submitted. 3.8 at page 28.
Page?
28.
3.7.
May I take my notes to 3.7 first before 3.8 minutes?
Main page 2.
3.7 at page 27.
Perspective of the-
This perspective of the foundational principles of the Indian Constitution was foreseen, appreciated, and applied by Chief Justice Sinha in his dissenting opinion in Sardar Saidna, where he declared the Bombay Prevention of Excommunication Act was constitutional. In that case, I can skip that. 3.7.1, Chief Justice B.P. Sinha observed that the 1949 Act was in fact a culmination of the long history of social reform legislation enacted in India, and that it was specifically aimed at ensuring human dignity and removing all those restrictions which prevent a person from living his own life so long as he did not interfere with similar rights of others. Chief Justice Sinha ultimately upheld the Act on the basis that excommunication degrades individuals by denying them social participation and civil rights, thereby violating their human dignity and their individual liberty of conscience. His opinion reasoned that the legislation was in furtherance of the strict injunction of Article 17, which abolished untouchability. And this was relevant in the context of the power of the dai, since an excommunicated person becomes an untouchable in his community. It is submitted that Chief Justice...
Difficulty is excommunication by nature of your birth or bachelor of situation, that's one thing. When it comes as on a pursuant to a decision made over individual person for A or B reason, then you have to go into the reason. And then the two things, you have to go into the reason as to whether it's justified or not. Then the question of proportionality was saying. It is not as if just because the other somebody is born in the other community, you are excommunicated, or you are considered to be impure. That is not the thing here. Therefore, to apply the other things, to what extent you can apply.
There is a balancing task, Willard, and that requires great care and circumspection.
These questions cannot be obviously it involves an adjudication on facts, and then you have to go into the adjudication of how it amends, whether it is proportional or not, whether it is right or wrong, what are the materials, whether it is religious or secular. Then all those factors would come. Ultimately, nobody is saying that you will be rebellious. The question will be, can you? It's look at it in a larger perspective. It is between you and the group you belong to. That's the ultimate dispute. The dispute may vary from on the facts of each case. But then to bring it under the constitutional law and then bring it and to tap the other provisions. And
if it comes to dignity, let us give small examples, Bharat.
Dignity again is a very loosely worded word. You can give wider interpretation. What constitutes dignity is different from person to person. And from See, it's from court to court also, it will have a different view about it. After all, we give our own view, opinion about it, yes.
There are words.
Yes.
Let us give everyday examples, words. In families,
See, for the moment, we are not pitching it too high to say that you will not be remediless. You may have a remedy.
In a given case,
Yes.
see, the question whether excommunication is good or bad, constitutionally valid or not, is one aspect. In a given case, the person excommunicated, he can always question,
Yes.
saying it is not a correct exercise of power. There he will go to suit. But
If-
here you are asking us to strike down excommunication because it is in violation of dignity,
Very wider,
etc.
very larger canvas.
25(1) is there, 26(b) is
if
there.
excommunication leads to civil death, then the court will intervene. If it is some kind of a minor punishment, obviously the court will not. This is an internal matter.
There a person who is excommunicated, who has a grievance, if his grievance is that the Dai wrongly excommunicated me, he can go to and file a suit.
In the meantime, his wife has divorced him.
The excommunication itself is bad. That is what you are asking us to do.
No, but in the meantime,
Declaration.
It's a difficulty.
while he goes to the civil court,
Prolong it,
Is-
for example, to give you an example. For a punishment under the code you can take, criminal code. A death can be given. Where death can be given on factual scenario, depending upon the nature of offense, the severity, and then so many factors are there. Nobody can declare it as no, there cannot be any death is unconstitutional.
Correct.
See, and then especially when your right to be a Daudi is not taken away.
it is
It-
effectively
it
taken away.
happens.
It is effectively taken away if I can't go
Correct.
to my
And
mosque.
Consequences are
You are
bad.
testing it based upon the impact.
That is the only test. In my respect
That
of
is
submission,
not, could there be a ground for a?
I am either right-
Court to entertain
I
this?
am either right or wrong on this.
Yes.
The test, in my submission, I put it in black and white, not ambiguously. The test is impact.
See,
And if the impact is
it is-
on my
it is very
human
difficult
dignity,
for you to bring it under 14, 14 will not come against the state. It will not come under 15, it will not be, it's again partially against the state, partially against the public place. 17 will not come, it is not quite a question of untouchability because you are excommunicated on a pursuant to your view, express a decision taken. See, supposing if had that, the incident had not happened, you would not have been excommunicated. Therefore,
I don't
it
need
is
any
not
of those
necessary.
rights except 21.
21 also difficult to begin.
21, according to me, is the core right. And that core right is available to me. And if this court sees that a 21 right has been taken away because my life has been
We'll tell you why.
degraded,
We'll tell you why.
my wife has divorced me.
No,
We'll
articles,
tell you why.
death penalty
See,
is
for
a total violation of
Oh.
Article 21.
Yes.
Can you say
takes away life of
death
somebody
penalty should go therefore from out of the statute book?
This-
Life is taken away.
With
Death
respect-
penalty is there on the statute book.
Actually-
Now today you are saying death penalty is bad because my Article 21 right is
Sorry.
affected.
Minute,
That
with
cannot be the argument.
with utmost respect, that is not,
Right.
with
Only
utmost
thing-
respect, that is a very wrong example.
pushing
With
us-
utmost respect.
You are pushing us to take a decision on the facts, on the decision of the.
Not his argument. Probably, Mr. Raju, this is not your argument.
Lordship, please.
You please complete it.
Yes.
and
See,
then
you
probably
are
we'll be
looking
able
at
to
the
understand what you are
person
arguing.
who is excommunicated. But the person who has the right to excommunicate as a religious act came before this court.
The,
Whose
pers-
perspective the court should view?
the individual, because he's at the heart of the
What
constitution.
about 26?
Minutes.
B then?
26 flows from 25. That has been the burden of the argument. The individual is at the center of the constitution. That is my argument. There can be no dilution of this argument. And it is for your lordships to consider or reject my argument. But it is the individual who's at the core. Now, minutes. Para 3.9. I'm not reading out in detail, but I have set out
Muthuswamy.
major dissents. Whether it was A.K. Gopalan or ADM Jabalpur or Justice Hegde, Justice Subbarao in Devadasan, his dissent. Or more recently, in the Narasimha Rao bribery case, Justice S.C. Agarwal and Justice Anand were in a minority. And just 3 years back, my lords, in this court, I was before a bench of 7 judges, of which Justice Sundaresh was also a part, where Narasimha Rao was overruled and I was laughed out of court trying to defend Narasimha Rao. It didn't take more than 2 days for your lordship to say that Justice Agarwal's dissent is the correct law and Justice Barucha's judgment was wrong. So these have been the moments, and I won't repeat it again except what I'm saying now. This is the moment where this individual centric dissent of Chief Justice Sinha should become the law of the land. Then 3.12 3.12, the living tree concept, which Ms. Indira Jaising has argued, constitutional interpretation has to move with the times. It's organic. Justice Amanullah's observation that meaning also has to change with times. That is the thrust of my reliance, Billots, on IR Coelho, National Legal Services Authority. And then 3.13, it is submitted that therefore practices under Article 26 are subject to judicial review on the ground of violation of any other fundamental right in Part 3, because in case of any conflict, each fundamental right is always to be considered in the context of the other rights. Courts must examine such cases on a case-by-case basis. There can be no definitive rule that practices under Article 26 have a greater degree of constitutional protection against scrutiny, or that they can never be prohibited by a court. If a practice under Article 26B seeks to violate another fundamental right, it must be restricted on this ground. And I come to the conclusion straight away at page 33, 3.16.1, no fundamental right exists in a silo. Article 26 cannot unconditionally protect a practice which violates another fundamental right. 3.16.2, a practice which is intended to violate the equality, dignity, and liberty of an individual or to extinguish their right to freedom of religion cannot be justified under Article 26. Then I come to the last question which I am addressing, which is constitutional morality. And Millards, there is a similarity. Mr. Ravindra Srivastava and I didn't see each other's submissions, but we are saying the same thing. There is nothing sacred about this particular word. If that word is irritating, then Millards, use anything else. Constitutional philosophy, constitutional ethos, but can be denied constitutional legitimacy, but can be denied that there is a core set of constitutional values which must inform the meaning of every word used in the Constitution, including the word morality. Now, Millards, in the course of the debates after the Sabarimala judgment, questions were voiced in incredulous tones, Millards. What is this constitutional morality? Some extraterritorial concept which is being thrust upon us. To ask what is constitutional morality is like asking today, what is basic structure? If there is a basic structure, then there is a core of constitutional values which constitute the constitutional ethos. Please don't use the word morality. And since Dr. Ambedkar was relied upon to say that he used it in a different sense, that is committee between institutions. Governor must respect legislature. Executive must respect judiciary, etc. That was what Dr. Ambedkar said at that time. But later, only because this is an evolving term, Millards, and I've put an extract. Where is that? Where Dr. Ambedkar talks of morality, constitutional morality, in the context of a majoritarian impulse against the lesser citizens. So we can't fix constitutional morality to what Dr. Ambedkar said at the time of the Constituent Assembly.
Therefore, you agree to that extent that this shield of constitutional morality used time and again by the majority opinion probably appears to be erroneous. There is nothing like this constitutional morality. It should have been talked of constitutional values, basically the principles which are also form part of the basic feature of the constitution.
That is enough, Millards. So let us not be detained by terminology, but
The expression constitutional morality has been used by majority as if it is on a higher pedestal as compared to the other moralities in the society, in the system, in a religion or in.
I would respectfully submit that constitutional morality or ethos, as we now understand it, is only a tool, not a test. And therefore, no law can be struck down on the basis that it violates constitutional morality. But a recent use of this term as a tool is, in the judgment of my Lord the present Chief Justice, in the 6A Citizenship Amendment Act case, where while upholding the amendment with regard to implementation of the Assam Accord, my Lord's judgment says,
Applied the principle of fraternity as a constitutional because
and that this doesn't also clash. It is not inconsistent with constitutional morality. Therefore,
But
we use it as a tool.
Mr. Raju, you agree that constitutional morality cannot be a touchstone
Yes.
to test constitutional validity either of legislation or of religious practice. So using the word constitutional morality in place of morality in Article 26 may not be a correct way of reading the provision.
I bow to that observation. And in
We
fact,
would definitely understand and appreciate your argument that 26 is not in silo. It requires also to be tested along with other fundamental rights, more particularly 21. But we have to test it against 21, as has been held also in the Madrasa case, that the basic structure theory cannot be a touchstone to test the validity of a legislation.
that is what we
Similarly,
understood, Millards.
practice by using a vague term like constitutional morality cannot be rendered nugatory. It must be shown to run counter either to 15 or to 17 or to 19 or 21 or any of these horizontal fundamental rights.
Millards, all those who grew up in the profession
The argument
after
that
Keshwana,
Dr. Dhawan has made it, so he also relied upon the judgment. Dr. Dhawan has also relied upon judgment to show. You can use it to a certain extent to
No,
understand what the particular article actually conveys. That's it.
Lordship, please, nothing more than that. What I was saying was, in the context of basic structure, was all those of us who started practice in the close aftermath of Keshwananda Bharati grew up with an understanding that this is to be used only to test constitutional amendments
Yes.
and not ordinary laws. But there have been some unfortunate aberrations where it has been used otherwise also, but that can't be correct.
Like in the Madrasa judgment, secularism was considered to be a touchstone on which the law was declared ultra vires, reversed by the Supreme Court,
Lordship, please.
holding that it cannot be a touchstone for primary legislations.
But are
I'm
you,
obliged, Lord.
are you using the touchstone of constitutional morality to seek striking down of the Sayadna judgment?
I'm not. I'm not. But I have one further submission to make. So let's not use the word morality. Let's use the word ethos.
Because we remember, even on the basic structure also, I think you did write up on this. You did make up a write up on basic structure, questioning it.
Yes, but after that, I become wiser.
Yeah. Yes.
I've spoken about my becoming wiser, Bullets. Bullets. May I
That is why
come now?
we come down back to the basic question. Can an Article 32 petition
Coming,
be
coming.
filed to strike down basic structure?
I've already reached Millard's page 44.
Yes.
I have to
No,
reach
whether
page
an
48.
Article 32 petition can be filed to strike down basic.
That is the subject matter,
We
Millard.
are coming down to the basic question.
No, when I reach page 48, when I reach page 48, then Millard's, if your Lordship will look in this direction, if Justice Nagaratna will look in this direction, then when I finish these 48 pages, this is what I am coming to. Now, Millards, 4.9.3, can I just take my lords for a minute and then come straight to my conclusion? 9.3. The link between constitutional morality and the test applicable under Article 14 is made absolutely clear in the case of In Re Section 6A Citizenship Act, where this Honorable Court reiterated the proposition that in order to pass the test of manifest arbitrariness, the court must prove that the concerned state objective requires alignment with constitutional morality. This Honorable Court further held that the test under Article 14 is not a mere formalistic study, but one where the court would undertake a normative analysis and strike down a classification if the object itself is discriminatory or leads to a prejudicial outcome not conducive to constitutional morality. Thus, it is submitted that the concept of constitutional morality is relevant at two levels. First, for determining the legitimacy of the object of the state, and second, for undertaking a holistic analysis of the constitutionality of a particular measure by evaluating whether the impact of the measure is not conducive to constitutional morality. Nothing more than that. And Justice Nariman Millard, in his concurring judgment in Sabarimala, while rejecting my argument as amicus on constitutional morality,
And disagreeing with the other majority, then
Justice Nariman suggests that morality would mean what accords with the norms of a civilized society. And the norms of a civilized society cannot be at variance with the norms of our constitution. So, that is the place where constitutional morality belongs. So, this is not some new threat to the constitutional law of our country. It is as useful a tool as any other tool of interpretation. And I come to the conclusion, Millets, at page 271, 4.15.1, page 42.
yes.
If morality is used as used under Article 25 and 26 was to be read as social, societal, public morality, this would open the door for religious freedoms to be curtailed on the basis of majoritarian notions which are untethered to constitutional text, and that this would result in an even more amorphous judicial inquiry. Such an amorphous judicial inquiry can be avoided by interpreting morality as the internal morality of the Constitution, referred to by earlier decisions as constitutional morality. The notion 4.15.2, the notion of constitutional morality as employed by this court under Article 14, sometimes read with Article 21, has a relatively fixed meaning referring to the set of values underlying the Constitution, and that the same understanding of the term can be applied in the context of Articles 25 and 26. Even a practice held to constitute a matter of religion under 26 may be curtailed or even prohibited if it is to be found to be contrary to the notion of constitutional morality, which your lordship may read as refined by what I have submitted. Don't use the word morality there at all. Use the word ethos. The notion of constitutional morality can be called by multiple names, including the ethos of the Constitution or the conscience of the Constitution. The phrase used to signify this reference to constitutional values is less important than the function performed by this phrase, which is to adjudicate fundamental rights claims through a value-based approach. Even the manner in which Dr. Ambedkar used the notion of constitutional morality in his speeches is not inconsistent with the understanding of the term as referring to the values underlying the Constitution, and further, that his understanding of the term was a dynamic one. Having made my submissions, words, on the questions framed and having addressed on 4 framed questions, I now proceed to address my lords on an unframed question, because I have to satisfy the doubts raised. But I make my submissions with a caveat. Just open this. Can we hand up the submissions? Yes. It couldn't be circulated yesterday. Result? Yes, that's right.
Are you referring to the supplementary note?
No, but I'm to address Justice Nagarata's question. In the end, I've come with a separate note.
Yours is here.
Yeah, okay.
Pull up on this.
2016 Act.
Everything is going to come, Minister. Everything is going to come here. If
And
If
Mr.
I have to
Raju,
go-
Mr. Raju, hopefully now in the new, the supplementary note, you are probably, or in any case, you need to very briefly point out what is the significant legislative departure from 1949 Act to 2016 Act,
They are broadly similar.
broadly said. So if 1949 Act had adequately brought, according to you, we are saying, according to you, had brought adequate reforms in terms of the power which is vested in 25(2), and as an existing law, if it could be, suppose, suppose it had survived, but for that, the fact that this court struck down, and now there is a new legislative regime that has come into force, then what is the apprehension you are right now having?
I have no apprehension at all. I,
What is the system?
Then, yes. Because to the 2016 Act,
Even otherwise.
because the old act has been.
Is not there.
Oh,
No prayer in the writ. Look, Mr. Raju Ramchandran, please come to your prayer in the writ petition.
prayer also, yes.
yes, Manoj.
Is there an application for amendment?
Yes,
There's
that
an
is the whole point.
What is that application?
Either I proceed now, according to my note, where every aspect of these doubts has been addressed.
Ole, proceed, please. No? Proceed.
Now, Manoj, since the view of one of the members of the bench on this issue has been expressed very strongly. Equally, Manoj, I, as a counsel, wedded to this court and its ethos and its values, I think your lordship will give me the indulgence of stating my viewpoint equally strongly. I think
First of all, let's be very clear. From our side, all observations are tentative observations. We are very unpredictable. We are extremely unpredictable. So please always keep in mind, stronger the question is, shows the stronger the doubt in mind we have, and we need to seek clarification.
I am obliged, Manoj.
But you have a right to present your case with strongest force.
Lordship, please. And counsel submissions can't be
Yes.
tentative. Counsel submissions can't be tentative.
You have the privilege to argue your case with strongest points, no doubt about it.
And therefore,
You have placed a copy of the new Act 2016.
yes, Manoj,
Act
it's
on
there. It is
record.
there. It is there. It is there.
That page,
Tell the page.
That's what.
I was reading all these things while sitting. Just for our record, in 2016 Act, Wyrie is not under challenge so far.
It's not under challenge.
Follow.
And the 5-judge bench, which sent me here dealing with this petition, records the fact of the existence of the 2016 Act, records the submission of the Solicitor General, apart from our own submission, that the question of validity of the practice of excommunication still survives. And therefore, the 5-judge bench has sent me here saying that of the 7 questions before the 9-judge bench,
No,
the following few questions.
the Act itself has been
Mr. Raju,
repealed.
the practice of excommunication was bound to survive because the 1949 Act had been struck down by this court, upholding by majority the practice of excommunication. So the practice stood revived by virtue of the judgment of this court, right?
Yes.
Now that practice has legislatively again acknowledged in the 2016 Act. If you go into the definition clause, it is again acknowledged that this practice is there, and that's why the prohibition and some penal consequences have been established.
Yes, Manoj. I'm grateful, Manoj. Now let me come to the opening paragraph of my note, which is with respect a note of protest. And I'm making these submissions very respectfully under protest.
Social boycott is prohibited now under this act.
Lordship, please. It is. It is. At the outset, the present submissions are being made in deference to queries posed by the bench on the question of maintainability. These submissions are, however, being made without prejudice to the petitioner's submission that, one, the question of maintainability of this writ petition or any other writ petition other than the public interest litigation referred to in question number 7 is not a matter referred to this honorable bench of 9 judges. 1. 2. This issue is not a matter which requires the attention of a 9-judge bench of this court. I'm making this submission with responsibility. If a doubt has arisen in some case, let it be decided when that case, including my case, which goes back to the 5-judge bench, let it be decided there. This is not, I say with the utmost respect, a matter which should engage the attention of a 9-judge bench where time limits have already been crossed.
Because this is not one of the 7 questions referred to.
Lordship, please.
Understandable.
Lordships, please. So when your lordships are hard pressed for time, other matters are waiting, other counsel are waiting. Why should your lordships, with the utmost respect, get distracted by this?
Question will keep it open and for to 9-judge bench then.
Yes, I'll take my notes.
The 5-judge bench could have considered it.
No, because issues were common here. What do I do if a 5-judge bench sends me here? Let me say, place a 5-judge. It's a detailed 5-judge bench order. Bench presided by Justice Sanjay Kaul, but the order is written by Justice Oak. Let me place that. Then perhaps everything falls into place.
Justice Oak's order we have seen.
But let me show it from my point of view because of questions which are raised.
Mr. Raju, this entire note is only on the maintainability.
On the maintainability,
We
We
think
think
that
we should not
need
go into it. We think we should not.
I'm grateful, Master.
We'll leave it again.
I'm
we
grateful.
Consider when the matter goes to
That's
5-judge bench.
I'm therefore very grateful to my lords.
5-judge bench.
Yes, yes.
Matter has to go to 5-judge
Yes,
bench.
exactly, my lords.
We'll decide.
I conclude, my lords, by expressing my gratitude to my lords for a patient hearing, to my brilliant young colleagues who have assisted me,
Absolutely, no doubt about it. Or
and my lords,
the entire Nandini and entire, they deserve.
and my lords, I started by paying my tribute to my senior Shamala Pappu. May I end by paying my tribute to my leader Indira Jay Singh. 62 years she has fought for the constitution. She has led us from the front, my lords. Grateful, Master.
Thank you, Mr. Rajaram.
Grateful.
Thank you.
So when the matter goes to 5-judge bench,
After that,
the question whether it could be referred to a larger bench can also be considered by the 5-judge.
I'm grateful, Master. Grateful.
They will refer it to 7th then. Because they are bound by the reference order or not. Or they can refuse to say, they can say that the reference itself was bad. There's a detailed order of reference.
no, Mr. Raju is not answering, but otherwise this issue in a way has been settled by the order of 10th February 2020.
I'm grateful, Master.
So
I'm grateful.
therefore, because as you are rightly saying that now that 9 of us are spending and investing, we are very long-term investment on certain judicial principles. Therefore, we would like to respond to those issues
Questions.
on merits, so that at least for posterity, whatever right or wrong the view we take, it should come on merits.
I'm grateful, Master. I'm
Certainly.
deeply grateful.
We also want to
appreciate.
know whether this board has made efforts to bring in reforms within the religious denomination, whether your board, petitioner board, whether you have made attempts to bring reforms within so that this excommunication practice is done away with.
There's nothing which we can do. There's nothing which we can do. It is for the Sayadana to do and to see the writing on the wall, to see that times have changed, that we are not living in feudal times.
The call is here, I think.
Yes. Whenever your lordship calls upon me, I'll address.
That will at the appropriate time.
Whenever my-
This issue we're not going into.
Yes.
No, no,
Grateful, Mr.
whatever your lordship wants to know from me, as far as respondent 2 is concerned, I'm happy to address your lordships.
If need be, then.
Yes, Your Lord. Because, my lord, as far as the judgment is concerned, may I only say one thing, and I leave it at that. I know your lordships are rising. A very pertinent question came from Justice Amanullah, that when you talk about excommunication, are you talking about blanket excommunication, or you're talking about excommunication based on social and secular grounds? My lords, I haven't had the opportunity of taking your lordships through the judgment. Para after para, the majority judgment says that because the act indiscriminately banned excommunication on grounds without making the distinction between religious grounds and social grounds, they were striking it down. They said if it was on abhorrent social grounds, we would have said otherwise. So the
Mr. Cole, tentatively, in Sidna's case, the majority could apply a very well-known principle of law by segregating the provision that to this extent it is constitutionally valid, and to this extent it amounts to exceeding the power, therefore it will be
right. But my lord,
doctrine of reading down was the best principle that should have been followed.
but my lords, today your lordships are only dealing with two
Tentatively, we are
questions.
saying we still also not a final opinion. Please, sometimes we fire on this side, sometimes on this side. Please don't misunderstand us. That's the only thing we are saying.
Yes.
It is a secular act or a religious act?
Plus, my lords,
What is the nature of that?
yes, plus the instances given.
Is it a secular or a religious?
I'm just answering it. A, the instances given with great respect are matters of prejudice. They're factually incorrect. Each one of them, magazine, cooperative society, are factually incorrect. Secondly, my lords, please keep in mind that as far as the power of Dai to excommunicate is concerned, it has been held to be an essential tenet for the reason that he is today the vice regent and representative of the Imam who's in seclusion, who's the progeny of the Prophet.
So long as it is a consequence of the violation or defiance of religious practices.
Absolutely.
The moment it crosses the Lakshman Rekha of social reforms,
right,
then it becomes.
Absolutely. But my lord,
And this is how the constitutional bench with greatest respect failed.
But my lord, with great respect, no one is quibbling over it. The question is, no one is quibbling over it. You can't pick up a bad instance and say a misuse would take place in future, so strike down the power. That can't happen, my
You
lord.
are absolutely right. The instances can't be the basis
Yes.
of forming a view.
Yes.
Broad principles can be the basis.
Right.
That what you cross becomes violative. What you, so long as you don't cross, it is very much within the.
And my lord, that is why only, as my lord the Chief Justice rightly said, the judgment of Justice Iyengar and other judges in detail deals and says that if on religious practices, tenets, and essentials, a person violently disobeys them, how do you maintain the purity and the strength of the denomination if the Saidna is not even given the power to excommunicate?
That was also to keep
The flock together, as they said.
to keep the community together.
Yes.
I think 25 deserve a better and a longer discussion in the judgment. It should not have been just passed through on.
In all fairness,
Maybe a better discussion.
may I in all fairness say, your lordships have not heard us. There are detailed paras dealing with 25.
We are not saying so. We'll jump in all this. Thank you. We'll come after lunch.
Very well.
With the court's permission, I am appearing in two matters. One is I appear in an intervention filed in the FGM matter, the female genital mutilation, on behalf of Miss Masuma Ranalvi. And I was also appearing in the Parsi woman's matter, which is Gulru Gupta, which your lordship has already heard substantial arguments by Mr. Ravindra Srivastav and Mr. Darayas Khambata. For the convenience of the court, what I've done is there is
You are representing whom?
Masuma Ranalvi. She filed an IA number 43032 of 2017 in a writ petition filed by Sunita
Yeah.
Tiwari,
Yeah.
286 of 2017. I have also tendered a copy of the written submission, additional submission, because the original submissions were really on the parent issue, but this is the additional submission in relation to the issues before your lordships today, as also a short note which you would have, which would be a brief note. It's called a brief note. It runs into 6 pages. What I've done is I'm seeking to respond to questions 1 and 2 jointly, which is at page 1 of my note. At page 2, question 3 and 4. Do you have this note? There.
Your original note is 6 page, but the additional submissions are threatening, running.
Not additional submissions are written submissions. I won't be filing anything further.
All right.
They are the written submissions. What I've done is I've culled this out because.
Not will be sufficient for you to address.
I'm sorry, not.
Not is sufficient to address it.
It's a 6-page note. I don't want your lordships to go into the written submissions. That you can read at your convenience.
Right.
And here also there are a number of citations made which are from the written submission, but I will not be referring to all of them because I'm conscious of the time constraint and I had asked for 1 hour. I will try and maintain it. I used to be a long distance runner and I know the timing is very crucial.
This side you need to wind up today because otherwise it will create.
I'll try and do my best to do it within the 1 hour slot. I'm not going to go beyond that. I'm quite clear. I think there are a number of colleagues, not Mr. Joydeep Gupta, Dr. Guruswamy, Mr. Hansaria, and a few others. Not. Shadan Farasat is also.
So 15 minutes we are sitting late, so we'll give 15 minutes additional. We are duty bound.
I don't think we have a practical side today what we will be able to do justice, my lord, and complete on this side.
That's right. We need at least half a day more.
Yes, let's start.
Even if I speed read, it won't be possible. That's my challenge. Now, just keep this note before this honorable court and kindly see page 1. I've addressed question number 1 and 2 together, and I'll just make the oral submissions with the headings of plurality of religion, the constitutional framework of 2526, B, nature of denominational rights, C, rights of minors, D, judicial protection qua exercise of religious identity and protection. Then I deal in the second section, questions 3 and 4, whether, and this is the section, subsections are, what is the scope of expression, public order, morality and health within Article 25(1). I will be dealing with Dr. Ambedkar's speech, then, but second speech more, really the 25th November speech, as also C, page 3, social morality and critical morality, the core distinction, moral populism versus genuine democracy, conservative and progressive versions of broad morality enforcement, F, the answer, public morality enforcement within democratic principles, and Roman 2, constitutional morality versus public morality, the judicial development, just refer to the judgments. Then there is a short issue on basic structure, Roman 3. Then at page 4, I will deal with question 5 and 7. I'm sorry, by inadvertently, question 5 was not mentioned here, but I've got it written by hand, Roman 3, section 3, question 5 and 7. And here it will be judicial competence, parents, patra, and PL jurisdiction. Article 25 not being absolute. Constitutional scrutiny of religious practice, parents, patra, and PL jurisdiction. And overleaf number 2, writ jurisdiction against non-state actors, the public duty, public function test, and then the conclusion.
The intervener is also Daudi Bora.
I'm sorry, what?
Internal is also Dawoodi Bohra.
Yes, ma'am. Lord, if I may begin with your lordship's permission. But India, as we understand it, is by nature a country of diametric plurality. We are not, in a sense, we can't really be seen as silos. And I talk about in the context of religions, not only between religions, but also between believers. Because under the same umbrella of different religions, you have different faith forms and different beliefs. And when you have these different beliefs, you will have three triads which we will have to consider. Inter-religious plurality, that is the multiplicity of coexisting religions. Intra-religious plurality, plurality of sects, schools, sub-traditions within a religion. And three, intra-individual plurality, which is, according to me, a very important one. The coexistence within a single individual of different faith forms. That is to say, as an Arya Samajist, if I go to a temple or a shrine, or a person who goes, an Islam believer will go also to a dargah, which is not really perhaps a pure form. And there are people who will go to Ajmer from different faith form, people who will go to Vaishno Devi different faith form. This is therefore, it becomes a very interesting test as to what is your religious belief. Then, of course, there is the Puritan who says, I will believe one and not another. And therefore, we will have to deal with partial, eclectic, syncretic, or the Puritan believer. And all of those are going to be protected under 25. And the third tier, which is the tier of intra-individual plurality, is something which, with respect, has not been considered enough. Because when we talk of belief, we are looking at a belief form which may be multi-dimensional, not necessarily unidimensional. When we look at Bomai, and I've put that in my note with the paras, just make a note, it's written page 805, but see 801, there is an interesting passage in Bomai on secularism, which I want to place at this point. It's at volume 5.7. The judgment will begin at page number 531, and please come straight away to 801.
Volume 5.7.
Yes, 5.7. It's 531 at 801. Possibly PDF 80. PDF is also 801. Third line from the top. What's it called?
Judgment.
I'm sorry. Third line from the top.
That's for
Second
freedom-
para.
Freedom of faith and.
Yes, my lord. I'll just read not 4 lines at the top and 4 lines at the bottom of the para. Freedom of faith and religion is an integral part of social structure.
1 second.
Justice Ramaswamy's opinion, my lord. At page 914 of the report. इसके बाद next खोलो. It's on the screen as well, lord.
Okay, no problem.
Lord, it's at 801 801 of the running page and 914 of the report. And the third line is on the screen. Freedom, may I read it? Freedom of faith and religion is an integral part of social structure. Such freedom is not a bounty of the state, but constitutes the very foundation on which the state is erected. Human liberty sometimes means to satisfy the human needs in one's own way. Freedom of religion is imparted in every free society because it is a part of the general structure of liberty in such a society. And secondly, because restrictions imposed by one religion would be an obstacle for others. In the past, religious beliefs have become battlegrounds for power and root cause for suppression of liberty. Religion often provided a pretext to have control over vast majority of members of the society. Democratic society realizes folly of the vigor of religious practice in society. Strong religious consciousness not only narrows the vision but hampers the rule. Now, please come to the bottom of that page, about 12 lines from 15 lines from the bottom. Matters which are purely religion. Lordship's got that?
Yes.
Matters which are purely religious are left personal to the individual, and the secular part is taken charge by the state on grounds of public interest, order, and general welfare. The state guarantee individual and corporate religious freedom and dealt with an individual as citizen, irrespective of his faith and religious beliefs, and does not promote any particular religion, nor prefers one against the other. The concept of the secular state is therefore essential for successful working of the democratic form of government. There can be no democracy if anti-secular forces are allowed to work, dividing followers of different religions, faith flying at each other's throats. The secular government should negate the attempt and bring order in society. Religion, in the positive sense, is an active instrument to allow citizens for full development of his person, not merely in the physical and material, but in the non-material and non-secular life. Hence, Pomai tells us that the state must promote religious tolerance, but also protect the right of each individual to follow their faith, which is personal in nature. Vivekananda mentions this very simply. Just keep a note of that. I won't read it. Just make a note. It's referred to at second bullet point on page 1. Vivekananda tells us
This issue directly and substantially under consideration in Bombay.
But Bomai, the issue was not directly,
These are
but
all
the issue of secularism
competent
was
stuff.
raised. The issue of secularism was raised not because that was the issue, because the governments were being struck down on the ground that they belong to a particular political or particular religious persuasion. That was the issue. So it is not that it was untouched. It was relevant to that. It was relevant. It was not something completely dehors or completely irrelevant to the controversy in question. Now, Lord, I will take your lordship a little further. And I'll just refer to, Lord, there's a note on Vivekananda, which I put in as the second bullet point, where he talks about men must develop beliefs. There are differences. I'm not going to read that quoted portion. I'll just tell you what it is. It's bullet pointed there. And the language he uses is interesting. A religion only like one set of fingers would be unnatural. We therefore see that if one religion is true, all others must be true. There are differences in non-essentials, but in essentials, they're all one. If my 5 fingers are true, they prove that your 5 fingers are true as well. Whatever man is, he must develop a belief, he must develop his religious nature. Now, this is the context of religion, which we will have to take this debate forward. But we have to also keep in mind that in 1950, we had a game changer. We got the Constitution. The Constitution changed the rules of the game because the Constitution brought out a series of rights. Things which were not rights acknowledged to us by colonial masters became fundamental to us. It was the recognition of what had existed in us by the Constitution, and the Constitution we gave itself. We also recognize the need for religious rights, and they also form part of the fundamental rights chapter. And therefore, we must, for the first time, we must consider this, that religious beliefs therefore will have to be seen, but to test them, and I say this is, to test them is to understand the contours of 25, sorry. Is it to be seen alone, or is it to be seen in relationship with other rights, and to what extent? Now, what is religion? It's really a set of beliefs. And every time you have had change in a religion, you've had reform. Reform brings out a series of new beliefs. For example, Ramanuja, in Hinduism, Adi Shankara, the Arya Samaj in Hinduism. Judaism led to Christianity, led to the Orthodox Church, led to the Catholic Church, led to the Protestant set of churches. In Islam also, the Sunni faith, the Shia faith, and thereafter, there are various sub-branches. So wherever we go, there are movements, and the need to reform religion becomes very important. Sikhism, for example, is an eclectic mix of what some may say were Hindu beliefs, but also it draws a lot from the Sufi movement. You have more sayings of the Sufi saints. On one page in the Guru Granth Sahib, and I had occasion to see it, the word Ram comes 27 times. But Ram as an embodiment of God, not Ram as an embodiment of a certain God, but as the name of God. The point is this: in every religion, there has been a series of reforms and reform movements. So are we to say that religious beliefs are to be static? Absolutely not. And that is where the constitution comes in, and that is where your lordships come in, and that is where parliament comes in. Therefore, when we look at the rights under 25, I wish to say this. 25 right is personal, it is subjective, it is conscience-based. It's a matter of belief, it's a matter of faith. Also stated by Vivekananda, also stated in Boumai's case. 25 does not contain the requirement of doctrinal purity. That will not come in 25. It allows me to believe, it allows me to profess and practice religion, not only imperfectly, selectively, but also in a Puritan fashion, in the purest form, where I believe that there should be no variation or no change. But when we see these rights in 25, when we see the belief forms that are protected in 25, we also remember that, as has been said by my learned brothers and sisters before, they're subject matter to public order, morality, health, and of course, most important provisions of Part 3. But these are words which are not surplusage. They are deliberately placed constitutional restraints in order to define the contours of what can be done in 25. This right will operate at 3 levels. Individual versus individual. My right to propagate my faith vis-a-vis her right to propagate her faith. We may be of the same faith. My right vis-a-vis the religious denomination, where I want to profess my right, but I'm told, like in the Parsi woman's case, sorry, you're no longer a Parsi, you're excommunicated. My right as the client I represent, a Dawoodi Bohra lady who complains about FGM, about female genital mutilation. I'll touch about it in a little while, a little bit about it later. Who has been excommunicated? Her father has been excommunicated, her child has been excommunicated. Now, in such a situation, there has to be a protection of that right as against the religious denomination. And the third is the right against third parties. Can I do something offensive in my personal belief, which will offend others or which will breach somebody's fundamental rights? Obviously not. It's like this: if I was to believe that manslaughter, that doing bully of a human being is part of my religious belief, would that be acceptable? Obviously not. It's murder. And that is the reason some of these rights, some of the issues that we are going to deal with are going to be excommunication, for example. And my learned friend Parmeshwar was telling me, don't open the IPC at all or the BNS. Excommunication for a matter is a form of wrongful restraint. Female genital mutilation, there's a whole series of offenses, and I'll show that to your lordship. Are we going to allow these practices which are violative of 21 rights? And there, I'm sorry to say, the debate of vertical horizontal will lose relevance, because am I not, if I am to be protected under habeas corpus, as your ladyship's minority view said in the judgment, in habeas corpus I have a right to be protected. Do I not have a right to be protected against bodily harm? And then let us come, therefore, as to what is the right of the denomination. Now, the denomination, and 26B therefore becomes interesting, protects the institutional rights. It tells us what we cannot do. It gives us a set of rules: inviolable, malleable, modifiable, because there has to be an upgradation also. But where the denomination goes beyond governing, goes beyond internal management and starts controlling the spiritual lives of its members to a manner where it goes beyond just guiding them, but constraining them in the exercise of other fundamental rights, I ask myself, would that be permissible? I believe it would not be. And let us also keep in mind, what is a denomination after all? The denomination is us. It is the individuals who form part of a denomination. There will be bodies, whether they are societies, there will be bodies, whether they are temples or institutions, there will be bodies across various religious institutions, which will all be comprised of individual members. If you were to throw out everybody saying that you don't follow the belief, there'd be a shell left of the denomination, there would be nobody left. Therefore, the denomination must be cognizant or sensitive to the belief of the individuals also and the rights of the individuals. Beliefs is one part, the rights is the other part. Otherwise, what we are really saying is 25, 26, which some friends have said on the other side, stand alone. The rest of the constitutional rights go out of the window. That is not the constitutional frame. That cannot be. And they can't even expect your lordships to do that. To ask your lordships to do that would be doing violence to part 3. The fact that 26 and 25 have been read together is the Devaru case. I don't want to trouble your lordships with that. But
Mr. Luthra, just for my clarity, does the Daudi Bohra community permit a person leaving that community? Because it's a belief. I can have a belief, but to be associated with that group where I call myself a Daudi Bohra, it is only when I do absolute obeisance or subjugate myself totally, 100%, more than 100% to the Dai. Can I come out of it? Suppose I said no. These things totally beyond acceptable limit, I come out. Are you permitted to do that? Or you cannot?
I'll just cross check. No. Yeah, there's no. I think there's a restriction on leaving. I don't think there is a restriction on leaving to my understanding of it.
Then it does not lead to any penal consequences. Suppose if you leave.
But the consequence will be on the children. The consequence will be on the family members and the children. That consequence may happen as a separate.
I live with my family because only on puberty is that bond signed. Yes, you have to sign everything.
And what more? At 7 is the practice of female genital mutilation carried out. I'm not going to use adjectives for it. I'm going to tell you what it is. Just 1 minute. I'll just take a moment. So, there are.
Mr. Luthra, with regard to female genital mutilation, we need not go into all these other rights. The word health, public health is good enough to put a trump or to a bar of this.
I'm grateful for your lordship, but that's exactly what I'm saying, Lord, because, and that's the reason, Lord, I was just telling your lordship, I was not responding to that query. Not the issue is simple. The nature of the injury is that the clitoris is either, the skin is either removed, and that has about 10,000 nerve endings. 10,000 nerve endings at the age of 7.
Irrespective of the fact that this is a mutilation of a vital organ of a female body or a person's body, and it impacts her health, reproductive health,
absolutely,
physical health, etc.
So emotional health, not autonomy.
The word public health would definitely be impacted if this.
Indeed, my lord. Indeed, Lord. Indeed, Lord, my Lord, that's absolutely right.
Can touch upon morality also.
Yes. But morality.
For what purpose it is done?
That's the issue.
There it touches morality.
Absolutely, it touches morality. The question is, it is a practice which is going to curtail a series of rights, not just one, and it falls within various sub brackets. And I must tell this court, it is even in this country, it is followed not amongst only this community, it is also followed amongst a section of the Sunni community in Kerala. It is followed amongst, it's a pre-religious practice. It came from pre-Judaism times. It is followed by the Coptic Christians. It's followed in sections of the Jewish community across the world.
Antiquity, expression of religion, etc. it is to be subject to public order, health and morality. And we do not see how an expression, an act which intrudes into individual physical autonomy, mutilates the vital organ of the body, would not fall foul of these
Absolutely.
expressions.
And an act not more crucial.
And as you say, a secular law like the penal code,
Yes.
making an act of mutilation of the body amounting to hurt or grievous hurt would be in the form of an 25(2)(b legislation, although it may not be a specific legislation of reform, but would definitely
Yes, Lord.
eat into the.
In fact, Lord, I'll just
religious.
pass over. It falls foul of as many as 3 statutes. Lord, just see that for a moment. I've done made a one-page note.
Otherwise, Mr. Luthra,
Yes, my Lord.
mutilation, but the word itself means that it does not serve any purpose. It is to contort. It's like a contortion to a human anatomy. Had there been some benefit attached, because a lot of practices are there, but those are for the good. But this here is pure aberration to a normal physical human anatomy.
And I'll tell your Lordship where the anguish comes in. It is done at the age of 7, when a person is a minor incapable of giving consent, and because it is considered to be part of a belief system, though not ordained by the Holy Book.
So that is mandatory and fundamental here. This is mandatory and fundamental under the Dawoodi.
That's the claim. And kindly just see this chart for a moment. It'll fall within hurt, grievous hurt by dangerous instrument because it's done performed using blade, sharp instrument,
Mr.
grievous
Luthra,
hurt.
one clarification.
Yes, my Lord.
When it's a 7-year-old child,
Yes, Lord.
it's the parents.
Yes,
Who naturally
parents or family members or
naturally
relatives.
are members of the Dawoodi Bohram community.
Yes, Lord.
They are required to give the consent with regard to this. And would it be, if they don't give consent, they will be excommunicated?
Yes, ma'am.
Okay.
And not the issue is this today. Today we have one litigant, my client, and a few more who are willing to talk about it and have suffered excommunication. The challenge is this, that a lot of these issues that will go on behind closed doors. And that is what we have to address. Lord, today, Lord, that is, just see for a moment, and your Lordship will see, Lord, hurt because it causes bodily pain, injury, and physical suffering. Why? And I put it in the right, my colleagues have done a hard work, Lord.
Is there any need to tell all this?
No issue.
Everybody knows.
No difficulty, Lord. I just put it in the section that falls in, Lord, and POXO is a Juvenile Justice Act also.
No, you have done well that you have
Summarized
hide.
for your Lordship.
That's all.
Just a summary, Lord. I don't need to get into details. That's what I said. Now, Lord, just to come back to what I was saying. Now, the tendency in religious freedom jurisprudence has been to, counterpose, not all the historical cases are, the denomination against outsiders of the state. A law comes in, the denomination says, look, this law is harsh. They challenge it as against state action or against third parties. Today, what we are looking at is the counterposition, where the rights of the individual member are impacted by the denomination. As I said, the Parsi woman's example are 2 stark examples before your Lordships, and the Dawoodi Bohra woman's example, which is another stark example. Both have lost their identity and their rights to be part of the community, to participate in the community, to even attend the religious ceremonies. And the Parsi woman's case, not the ability to attend your parents' last rites.
So is there no law banning this mutilation?
No specific
yet-
law, no specific, no, I must point out. 59 countries have banned it in the world. In India, there is none. 59 countries have banned it. In 2 countries, there are judicial decisions. One is Egypt and one is Australia, which have given decisions by judicial decision making. There has been a ban.
Mr. Luthra, you are specifically on this issue only.
On these 2 issues. No. I'm on these 2 issues. One is the Parsi woman's right. The Parsi woman who gets excommunicated on marriage, and then the FGM. But as I said, I'm not going to dwell on the facts of these cases. It has already fallen to the Chief Justice.
For FGM, the argument will be substantially in a different direction. That will be more pointed and
My lord,
slightly off track from the main general.
my lord, in fact, I must tell your lordship, I'm grateful your lordship has said that. In both cases, the effect is excommunication is one of the commonalities. It's a common consequence of it. One is by doing a physical act, the other is by restraining me from access.
Impact of consequence. What was the issue?
Yes, ma'am.
But all these,
This is where you are challenging Saidna's ratio. That if female genital mutilation is a part of matter of religion and that affects physical health of the woman,
Yes.
and that minor child
They allow this female genital mutilation to happen.
So it's not necessarily that secular act is only which results in excommunication,
Yes.
which needs to be looked into.
Absolutely.
But certain religious practices making serious intrusion into physical
Bodily health,
bodily
autonomy,
autonomy.
sexual health, mental health.
Double impact.
Yes, my lord.
Physically causing all these things to a person at a very young age.
Yes, my lord.
And secondly, also the impact on the parents, if it is excommunication, then their social, they are cut off from the society. So this double impact.
Indeed, my lord. Indeed.
Emotional is third one.
Yes, Lord. And mental, Lord, because this is a trauma, it also impacts your life. It impairs you for life because it is something, Lord, it's not like, I must tell your lordship, it's not like an injury which can get reversed.
Exactly.
Today, I must tell your lordship, we have a senior plastic surgeon in the family. If a hand is cut off within few hours, you can join it back. But once the nerve ending flow, they're gone.
If something like your tongue is cut off,
Absolutely, Lord, it's gone.
it's not going to regrow.
Absolutely, Lord.
Serious.
Lord, it is a belief. It is a belief, Lord. It is purity. It is control,
The
Lord.
sense of challenging woman's sexuality,
Absolutely, Lord.
identity.
Identity, autonomy, sexuality, control.
Here impact will be multifold.
Absolutely, Lord. Absolutely. Yes. Now, Lord, therefore, as I say, when the right of the denomination comes in conflict with the right of the individual believer and it curtails its fundamental rights, then the balance must tilt in favor of 25 and cannot remain in the contours of 26. That's the point I was seeking to make. Because denominations.
supplement with one word more.
Yes, my lord.
That even the expression right becomes a very complex question.
I'm
That
grateful.
what is the right that a denomination will possess that, or an individual possess? That right itself also becomes worth defining.
Lord, your lordship has not put it better than I will, then therefore I will not dwell on it. I will just touch upon one aspect of the matter, Lord. Keep one thing in mind. There will be three levels where you will consider it. One is at the level where the community or the denomination impairs a minor's rights. That's really simple. Because when it's a minor, the question is lack of consent, that the matter goes on. A minor can't give consent. Then the question is the power relation. Even in the context of sexual offenses, we realize that power equations are treated as a more severe form of breach. That's the recognition which we've had across the board, even in the context of the workplace where you said power equations create a problem. Therefore, we had Vishaka's judgment. So today, my submission to your lordships is whether it be minors, whether it be individuals, we are pitching the mighty denomination against the individual believer. And if the individual believer, not today, feels oppressed by such a practice, are we going to quibble on the issue of whether it is essential or not? Or are we going to say it is violative of 21, 19, 14, and are we not going to throw it out? So this is where I really want your lordship to consider it. Now, not the next section.
Within Article 25(1) itself, the riders are there.
Absolutely. But then 26B has to be read, therefore.
That is also with the same riders.
It has to be read, it has to, and it has to be read, no, but
Hey.
it also has to be read.
Sir, Ludra,
So,
what my sister is saying this is this. 26B would come over a religious practice which is otherwise acknowledged.
Yes.
Unless the state feels it's a case of social reform or social welfare. But 25(1), though it's a positive act, it limits such a right, positive right, that's right. Therefore, you can't even do, that's what the sister is saying. If you can't do, then it is not open even to think of doing it. It will not come and see the second part which say about conscience, the freedom to proper practice. It will not come within the bracket, is what sister is saying. Therefore, it is better for you to bring it under 25(1)
yes, Lord.
than to rely upon anything else.
Lord,
Yes,
Under 26,
I am very clear.
the same three riders are there. Public order, morality and public.
Ladyship, I seek to go a little beyond. Because 25(1), my rights are there, which is subject to part 3, and I am the believer which forms the denomination. 26B has to be read as it fallen from my lordship cohesively. It can't be read disjunctively. That's
What we are saying.
I understand.
The practice itself cannot even be
Absolutely.
followed, yeah.
I completely, Lord, I completely
No,
concur with
Mr. Luthra,
Yes, Lord.
if I've understood the final point of argument, probably you are giving us a very novel proposition. If I've understood you correctly, I'm just explaining myself. You mean to say that even otherwise, on this touchstone of the overall constitutional safeguards to a citizen, which is unalienable and fundamental, even DHOS 25, 26 to that extent cannot be given effect overriding the individual. So it is,
Yes, Lord.
6 here may not be dependent on 25.
Yes.
Even if there is no interplay still, even on 26, that guarantee cannot be enforced, especially in these matters. Is that
Yes,
the
that is one part of it.
it's slightly a shift from the main. It
That
is not directly, it doesn't have to be directly dependent on 25.
Lord,
Independently also, those practices or those aberrations have to be taken care of, and the court has to intervene in judicial review.
Lord, and I must tell your lordship, that is the reason I said when we deal with minors, when we deal with people who are, I would say, less privileged because they don't have the ability to come to court because of the consequences that befall them. Is it not, I ask myself, is it not part of the access of justice that I can come to the court under 226 or 32?
So what
Because
will
if
be the
I
effect-
don't, where will I go?
What will be the effect in?
Ultimately, we revert back to as my brother is asking, the effect is that if you refuse to obey this perceived religious dictate, the consequence is your excommunication.
Yes, ma'am.
And therefore, question of relevance of 1949 Act comes into, and the view, how it has been upheld through para 61 by Justice Iyengar's view, that becomes subject matter of reconsideration. We understand this probably.
That's the point.
Nothing
That's the
more
point.
you
I
require.
just
That's
need to
the
clarify,
point.
this is not one of the grounds of excommunication.
It's not a ground.
This is not a ground for excommunication. And also, Lordship, factually, of course, the fact that it's not mutilation, the fact that it's a wrong description of the practice,
Lord,
etc., that's separate. But this is not a subject matter of excommunication for sure. So that's factually
May I
incorrect.
just-
According to
Sir,
the-
if I-
No, Lordship,
Please,
nobody gets excommunicated.
Yes, please clarify this.
Lordship, please.
She's been
If
excommunicated.
the parent, father
Lordship, please.
of a minor 7-year-old girl refuses to go through this process, will he be in breach of the dictate of the die or not?
Lordship, there is no temporal consequence for a spiritual act. Like, for instance, if I'm not offering namaz, there is no punishment for not offering namaz, no matter how mandatory it is. Therefore, there is no excommunication and there is Lordship, please.
Offering namaz. It's a question of doing an act in breach of the dictate of the die.
There is no worldly consequence, Lordship, in the Dawoodi Bohra faith to this non-adherence to this practice.
Pacha,
Lordship, please.
consequences are there because the Act says so, 1949 Act says so, Supreme Court judgment says so,
In
consequences.
religion, there are no consequences, Lordship, is what I'm saying. So no excommunication, no religious sanction.
There are no
So
consequences.
is it an optional thing?
Lordship, that's why I took the other example. It may be mandatory, but that doesn't mean there is a worldly sanction behind it.
The moment it is mandatory, mandatory refuse.
That is sufficient.
How can it?
Ah.
Lordship,
You answered the
Mandate.
question.
it's like circumcision for boys. There is no worldly sanction for anybody who doesn't get circumcised, however mandatory it may be. It's an individualistic practice. It's
From
a
a public health point,
Lordship,
there
please.
is a clear difference between circumcision
Absolutely.
and a genital mutilation.
Lordship, and so it's actually on facts that this question is being met because it's a wrong description. It's not mutilation. It's actually symbolic circumcision.
Genital circumcision of the clitoris.
Lordship, which is called,
Cannot be equated to
which is
circumcision
called,
of the
it's
male.
called hodectomy in the West, Lordship, and it's on the facts of the practice that practice is being, this argument is being met.
No, what is the object of it?
Lordship, the object in the religion is to increase the sexual pleasure for the woman because the opening of the tissue on the prepuce of the clitoris helps to increase pleasure. It's called,
Talking,
It is to suppress
your facts
the
clear.
sexual
Lordship,
activity of
it is
woman.
just the opposite.
Lordship, in fact, there is a practice called hodectomy in the Western world.
Mr. Pasha, I'm very surprised you use the word analogy to circumcision. Circumcision is a sunnat of the Prophet.
Lordship,
It is not mandatory. When
Lordship-
it is mandatory, kindly get your facts correct. Don't use it so loosely.
Lordship, it's
Connected with the circumcision.
Lordship, so the Dawoodi Bohra faith treats that injunction as
Limit yourself to
children.
Dawoodi Bohras. Don't come on the basic Islamic.
Lordship, I'm only on the Dawoodi Bohra faith, Lordship, because I represent, in this matter, I represent
Circumcision.
the community.
Use comments on a religion.
There are 60,000 women from the Dawoodi Bohra community who have formed an association to come and represent before my lords. I speak for them.
Back to a pure legal question of law, that legal question, pure question of law, reverting back, as we were just winding up before lunch, we're saying that when we were reading the majority opinion,
Lordship,
upholding, striking down the 1949 Act,
Lordship, please.
we were just indicating that the doctrine of swearability could be applied by that at that time.
Lordship, please.
And therefore, to the extent the act was not meeting with the principle of proportionality,
Lordship.
that could be struck down.
Lordship, please.
And to the extent it was within permissible parameters, could be upheld.
Lordship, and this
Therefore,
practice,
test of reasonableness should have been applied instead of going with just one hammer, that because it violates 25, 26, strike down.
and Lordship, this practice is not covered by excommunication. There's no excommunication for this practice. I want to clarify.
That's why right now we are afraid of going into facts, individual facts.
That's right, Lordship.
General principle we are-
That's right, Lordship. So therefore, the description of the practice and the fact that it's mutilation, all of it, we are meeting on facts. But on the
We are only evaluating on the premise, on hypothetical basis, that if it were to be a practice, then what is the consequence?
Lordship, so no excommunication for this practice.
Let this practice, if you refuse to follow this practice, then it is excommunication. and
Not at all,
if it is
Lordship.
Excommunication, then question of 1949 test comes.
Not at all, Lordship. That's the categorical submission on instruction that there is no excommunication.
It's mandatory.
The moment it is mandatory,
It's
it has to be judicial. It has to be.
Lordship,
For unnecessary diverting, excommunication, maybe divorce of excommunication, the moment it becomes mandatory, then we have to test whether it is justified, whether it can be.
Anything
For the
else?
Constitution of India and in India.
10 minutes more, Lord. 7 minutes, not just 2 points. No, not 2 points, 2 more points, and I'll not 5 to 7 minutes more, and I'll conclude. But therefore, as a consequence, I say, no denomination can seek constitutional protection. Just as not, though I can seek the right, the denomination cannot seek constitutional protection for practices which would fail on the anvil of fundamental rights. That's the point I wanted to make.
Pardon?
No denomination can seek constitutional protection under 26B for practices, if examined by the court, would fail the test of fundamental rights because of 25(1). That's the point I wanted to make as a consequence of all of this.
That will depend upon case to case basis. That may not be generalized as.
Lord, I'm making a legal point on this. My Lord may consider it.
Fine.
I'm not, therefore, as I say, that Narasu Apu Mali will have to be put to rest, as there have been observations that you can't keep the provisions on faith outside and untouchable against the fundamental rights chapter. And I'll leave this part. Now, Lord, the last 2 points that I wanted to make to your Lordship were this. Firstly, Lord, there will be an issue on the nature of jurisdiction. It's a question you've asked many times over as to who can come, who cannot come. The point is this, as I said earlier, if somebody does not have access, this court has parents patria jurisdiction. You've exercised it many times over. Not only that, when it comes, as in the Parsi woman's case, against a society, because the trust is a society, the body is a society, to not allow a writ to protect these rights, your individual rights of belief, my lord, would make it completely, because what they exercise under 26B is a public duty. Under 26B, it's not a private duty, it's a public duty. Therefore, 226 and 32 are therefore by implication clearly made out, and that's the point, Lord. I've given the judgments of Andi Mukta, BCCI, Kaushal Kishore. I don't want to say more. The last point before I conclude, Lord, is this. There is an issue of constitutional morality, social morality, and I want to tell your lordships, we will have to test anything in law, not by social morality, not by majoritarianism, but by critical morality. That is to say, social morality will be plural by nature. Critical morality is what the law ought to enforce. And here, the grand norm is the Constitution and the Fundamental Rights chapter. And therefore, it is critical morality which you are called upon, Lord. Even when a legislator is asked to represent his people and be the voice of his people, and I talk of a legislator, the legislator is still bound by the oath on the Constitution to uphold the Constitution and the laws. He or she cannot go beyond that into violence to the Constitution.
So that both sides are broadly agreeable.
Yes.
That constitutional principles are actually known as constitutional morality.
Yes.
That
Yes.
whosoever hold in a position and responsibility, then he must adhere to those constitutional responsibilities.
Yes, Lord. But therefore, I will leave your lordships with not just one quote which I want your lordship to read, and I'll finish with that. And just take this one out. Just see this for a moment. Lord, just see. This you will find. Is it being uploaded? Where is it? 6.1.8 of the compilation I've tendered today, Lord, page number 16. I'm just going to conclude by reading this, and 6.1.8, Vivekanand, Lord, says,
Page.
Lord, it's page 16 of my compilation, Lord. This will be in the compilation. In be page 21 in your lordship, Lord, it's been uploaded today. Ma'am, we'll have to ask the mic as well. It's been uploaded.
Yes.
6.1.8.
It'll be in the compilation, Lord, not here. It'll be in 6.1.8 in the compilation. 6.8. Volume 6.8. Volume 6.8, Lord. Volume 6.8. I'll read it.
Page.
Lord, it's page 21 of volume 6.8. Just make a note. The question is there a way out? To put it in a more concrete form, is religion to justify itself by the discoveries of reason through which every other science justifies itself? Are the same methods of investigation which we apply to sciences and knowledge outside to be applied to the science of religion? In my opinion, this must be so, and I'm also of the opinion that the sooner it is done, the better. If a religion is destroyed by such investigations, it was then all the time useless, unworthy superstition, and the sooner it goes, the better. I am thoroughly convinced that its destruction would be the best thing that could happen. All that is dross will be taken off, no doubt, but the essential parts of religion will emerge triumphant out of this investigation. Not only will it be made scientific, as scientific at least as any of the conclusions of physics or chemistry, but will have greater strength because physics or chemistry has no internal mandate to vouch for truth, which religion has, unquote. I'm deeply obliged, not your lordships have been very patient and kind, and grateful for the hearing.
Thank you. That was good.
I've also kept to my time, despite my friend Mr. Pasha's.
Lord, my submissions are also pending.
Pending, yes, these are definitely pending.
Whatever it could be found out today.
Don't doubt our memory.
I have not been heard yet.
May it please your lordship, my lord. My lord, I appear in the Sabrimala matter for the state of Kerala. Now, my lord, I start by saying this, my lord. Since I'm representing a state in the midst of a political change. Therefore, I am going to disappoint a lot of people in this room by not addressing your lordships on Sabrimala itself. Though if your lordship has any questions, my lord, I will certainly answer. Secondly, my lord, I am not shirking my duty here because when the matter was referred to your lordships, the express question raised was whether it should be decided without reference to facts. And your lordship said yes, just like TMA Pi Foundation was decided without reference to facts, we can decide these questions without reference to facts. And as your lordships have already seen today, a little bit of yesterday and today, the moment, my lord, we go into the facts, my lord, the atmosphere, my lord, becomes a little different. Anyway, my lord, the second reason why I'm saying I'm not shirking my duty is, my lord, even on the opening, your lordship, the Chief Justice, my lord, said that we do not have to get into the facts.
I think the opening remarks itself seems to be correct. The reference order, to that extent, speaking for myself,
Lordship.
it should have been a composite order, composite judgment. The segregation itself will become a very difficult judicial exercise.
It has.
Which now we are duty bound to perform
Yes.
because of our own order of 10th February, but it should have been a composite reference. All issues ought to have been decided through one judgment only.
But, my lord, your lordships can take it like that. You can combine it and read it as one order. Because, my lord, the first one refers to the fact that there is going to be a second one. So you all can take it, my lord, to be part and parcel of one scheme. Now, my lord, so therefore, my lord, I have in a sense, my lord, a difficult task because, my lord, the state is going through a change. At the same time, my lord, it is a real pleasure that I do not have to defend a particular client, my lord, at this point of time. So I can make my submissions free of, my lord, almost.
No, and he will know who is his client and what is their position.
We were
Well-
just Gupta.
3 times.
Already it has been changing.
Round, there will be a 5th round. And each round, the position has been different.
Positions have changed already.
We were discussing.
We don't even know if there's a caretaker government as yet.
So there isn't.
You hope your stand would not be a stand to take, not to take a stand.
My lord, I have a stand to take. I'm just not bringing it to your lordship's attention at this point of time because, my lord, it is not necessary for the purpose of this reference.
As a council, you are today sui generis.
Sui generis. I've never been like that ever. Now, my lord, my learned friend, my lord, says that we have changed our stand. But, my lord, please see, these are very, very seminal issues in the Constitution. Your lordships have changed your stand from time to time, and today you're sitting to actually decide whether it is necessary to change your stand again. So, my lord, if a state pays attention, my lord, and takes different decisions at different points of time, then, my lord, there is nothing wrong with it. Ultimately, my lord, we are before your lordships. If I make a legal submission to you, if you think it is right, accept it. If you think it is wrong, you do not accept it. There is nothing wrong, my lord, with the way in which, my lord, the state has handled it. I must tell your lordship, I had specific instructions when I argued the original matter to oppose the, my lord, ban on entry of women. I had specifically that it should not be, my lord, thought that I did it on my own. My own opinions do not matter. I specifically asked for instructions from the very top and they said, yes, go ahead. Now, that's enough, my lord, about all that. Now, only one thing I want to say, my lord. Sabrimala, my lord, is certainly a very complicated and very unique fact situation. My lord, the entire structure of Article 2526, which is before your lordship today, my lord, should not be affected by referring only to Sabrimala or indeed, my lord, by referring to the facts of any particular case.
Exactly.
Your lordship is taking, my lord, a decision on the interpretation of the Constitution of India. With that, my lord, caveat, I move on to, my lord, one more point, my lord, which is just housekeeping. My lord, originally we had filed a written submission which only gave answers, did not discuss. That is found, my lord, at page 155 of volume 1. Now, my lord, I have prepared a detailed submission which is in the nature of additional submissions and which is to be found in volume 2.5. This one, my lord, the second one, I am giving you, your lordships, my lord, a hard copy. This comes, my lord, along with, my lord, a volume of judgments which support this, which are not already filed, my lord, in the my lord, compilations, which have already come before your lordship. But today, it has all been uploaded. Additional submissions plus the judgments relied on there, which are not part of, my lord, the precedents volumes, volume 5 precedents, all are together, my lord, now uploaded also. But I'm handing across, my lord, the hard copy as well. Now,
This is also uploaded
yes, it is up as
volume?
2.6, 2.5, volume 2.5, it is uploaded. And even though your lordship is getting 2 volumes, but now it is in the digital form, my lord, it is only 1 volume altogether. Now, uncharacteristically for myself, my lord, this written submission goes on for 39 pages. But I've just one word, my lord, to explain it. The actual propositions are much less than that. It won't be more than 6 pages. What I have taken the liberty of doing, my lord, is to extract, my lord, certain portions from certain judgments. Because I do not wish, my lord, to take your lordship to different volumes here and there. If I wish to place, my lord, a particular portion, and I will not place the whole of it at all. If I wish to place a particular portion, your lordship will find it here only. You don't have to go anywhere else. Good. Because, my lord, when you are listening to arguments, it is necessary that your lordships be as free of paperwork as possible. Because then we are, my lord, communicating. And your lordship, my lord, is communicating with us as well. With these 2 points, my lord, I come to one preliminary issue. And the one preliminary issue before I come to the 7 questions which your lordships have, my lord, posed. The one preliminary issue, my lord, is the doctrine of precedent. Now, Mr. Ravindra Srivastav, my lord, has addressed your lordship on that. I'm only, broadly, my lord, those are my submissions. But, my lord, I'm only emphasizing 2 aspects. Admittedly, one aspect of the doctrine of precedent is that a higher court is binding on the lower court. To that extent, my lord, by constituting a 9-judge bench, there is not a single precedent of this honorable court or any court in this country which is binding upon your lordship. That aspect of the doctrine of precedence does not at all, my lord, come into play. But however, my lord, there are 2 other propositions, my lord, in the doctrine of precedence, which I wish to emphasize. And, my lord, these have been taken from House of Lords judgment in Bone versus Keene, which has been accepted in Halsbury, and those passages have been accepted by your lordships, my lord, in several judgments, 2 of whom I have placed, my lord, Maktul versus Manbari, and which is an old judgment, 1950s, and Sakshi versus Union of India. And, my lord, the precise point that I wish to make, my lord, is contained in one paragraph, which is an extract. If your lordship, my lord, just permits me to read 2 lines. Yes, my lord, just 1 minute. Page 4, para 6. Now, this is the summary in Halsbury, which has been, my lord, accepted by your lordships. Lordship has?
Yes. Yes.
Law on this point is summarized in Halsbury 2nd edition, etc. Apart from any question as to the courts being of coordinate jurisdiction, a decision which has been followed for a long time and has been acted upon by persons in the formation of contracts or in disposition of property or general conduct of affairs or legal procedure or in other ways, will generally be followed by courts of higher authority than the courts establishing the rule. In other words, my lord, though not binding, normally even a higher authority will follow the lower authority. Unless, my lord, there is some specific reason which requires your lordships to deviate from that, that of course, my lord, your lordship will. Suppose it is a wrong interpretation which has been laid down and followed for 75 years, certainly your lordships will. If it is producing some kind of inefficiency, then also your lordship will. That's it. Now, your lordships are of course aware that the scope and effect of Articles 25, 26, interplay, everything has been the subject matter of intense debate in this court for 75 years. I'm only saying, my lord, that the wisdom of those 75 years, my lord, should be scanned. And then your lordship may take whatever call you wish to make. Now I come to, my lord, your lordship's first question. Your first question is scope and ambit of the freedom of religion under Article 25 of the Constitution. Now we are, my lord, in the my lord, arena of interpretation of the Constitution. I will only, my lord, make one submission here, that treat the Constitution as a document of governance. It is undoubtedly so. It is for the purpose of governance of this nation, my lord. It is not a spiritual document. So, my lord, when you define religion, let us say, for the purpose of Article 25, or when you define religious denomination for the purpose of Article 26, you are doing it for the purpose of, my lord, interpreting a document of governance, not a spiritual document. So, my lord, an Acharya might well come and tell your lordship, this definition of religion is wrong. But that's not, my lord, your lordship's, my lord, primary intention in defining or, my lord, trying to understand the word religion. It is to understand it in the context of governance. This, my lord, is sometimes referred to, my lord, and of course, my lord, we have come across it only very infrequently, as the policy of the law. So, my lord, sometimes if there is no rule of law, there is a policy of the law. The policy of the law is an underlying principle or social purpose that guides how laws are created, interpreted, and applied. So there might be, my lord, an underlying principle which your lordship may wish to follow in such cases. Now, my lord, come to Article 25. First, I'm addressing your lordship on Article 25(1). Now, there are a few propositions here. These are all propositions which have been laid down already. I am not, my lord, here giving your lordship something of my own. Certain, the first three propositions, which your lordship will even find in the index itself, are, my lord, more or less accepted by everybody here. The first proposition, my lord, if your lordship sees my index only, religion has not been defined in the Constitution and is hardly susceptible of rigid definition. A religion undoubtedly has its basis in a system of beliefs or doctrines which are regarded by those who profess that religion as conducive to their spiritual well-being. These lines are taken from, my lord, Chirurman. I don't believe, my lord, that it is necessary to have a definition, because in each case, as and when it comes up, if your lordship is called upon to decide whether this is a religion or not a religion, then sufficient guidance is available to your lordship in the facts of any case. So this is not, my lord, an issue on which too much debate is required. I respectfully submit that this may be accepted as a working definition of religion. In this context, the dispute as to whether something is or is not a religion has rarely arisen. Because, my lord, of course, the principal religions of this world are well defined within themselves. This question has arisen only if somebody comes and says that the teachings or sayings of a particular person led to the creation of a new religion. I'll give you, Lordship, two instances where this has happened in this court. One is, of course, my lord, the teachings of Aurobindo. In S.P. Mittal's case, the very first point was, is it a religion? And therefore, is it a religious denomination? But the court said, after, my lord, elaborate discussion of, my lord, various writings, and also after considering what Hindu religion is otherwise, it said that no, this is not a religion. But there is a dissenting judgment, my lord, we are not concerned with it. I am only illustrating that only in very rare cases, my lord, will your lordship be ever called upon to decide what is a religion, whether something is or is not a religion. And the reason why somebody may want to do that is because they are trying to avoid the consequences of it being a religion. Two other instances which will illustrate this point. The Swaminarayan case, my lord, it has too complicated a name, my lord, I keep forgetting when I'm on my legs. The Swaminarayan came and said, we are not Hindus. Why did they say that? They said that because if they are Hindus, then the temple entry law will ipso facto become applicable to them.
They wanted to be outside that.
They wanted to be outside the temple entry law, so they said, we are not Hindus. Court said, here is what Swaminarayan's teachings were. We think that he was definitely a Hindu. He has benefited the Hindu religion with his teachings and activities, etc., etc. So they rejected that contention. That was one instance where the dispute was, is it a religion or not? And the purpose of it was a little collateral, if I may put it that way. The second one, my lord, is also very interesting. When the Ramakrishna Mission matter first went to court, first argument was, it is not Hinduism. It is Ramakrishnaism. And when everybody said that, but would Ramakrishna have said that this is a new religion? The answer given was that did Jesus know that he was creating Christianity? The High Court, my lord, accepted that proposition. But here in the Supreme Court, not only was that proposition not accepted, but the proposition was given up because it was too much. And my lord, there was a lot of unrest, my lord, amongst the Swamijis saying that how can we take such a stand? Now, why was that stand taken, my lord? Because the Rohira Ramakrishna Mission School was facing, my lord, state interference in matters of administration. So they wanted to say, first of all, that we are a minority institution. This is just to illustrate to your lordships that the question of religion is usually not something which will trouble your lordship. I come to the second proposition, which is also now completely accepted.
It all depends upon the nature of the dispute.
Yes, correct. Absolutely. But it will appear only in very, very limited situations.
Yes.
These are the three situations where we have found that this question arose. The second proposition, regarding which, my lord, there is absolute unanimity, is that the guarantee under our constitution not only protects the freedom of religious opinion, but it protects acts done in pursuance of the religion, religious practice. Overt acts are covered, my lord, there is no question of it. So, my lord, though I have painstakingly, my lord, given your lordship all the extracts from the various judgments which say so, I don't think, my lord, it's necessary to spend another minute on this because it is completely accepted. Then I come to the third proposition, which also, my lord, arises from Shirur Math, but which, my lord, is more or less accepted. And it's a little important here because, my lord, this will have some impact on the interrelationship between 25 and 26. That is, in Shirur Math, my lord, it was said that the rights conferred by Article 25(1) are rights conferred on individuals, because Article 25(1) says all persons. So the question arose whether the Matadipati of the Shirur Mat was a person. In defining this, the question, one argument was that Matadipati represents an institution, so he's a corporate body. Answer was no. 25 is not for institutions. 25 is for individuals. And this helps us, my lord, to understand the scheme very much. So the Matadipati is an individual who is entitled to practice his religion under Article 25.
He can propagate also.
He can propagate also. And in this context, my lord, one passage which really helps to understand, my lord, the way that we should look at all persons is that, kindly see, my lord, para 26. I am reading this because I cannot for the life of me, my lord, be more felicitous than, my lord, this passage. Para 26, my lord. Page 10, sorry, yes. Or if your lordship permits, my lord, yes, only 26. The rest of it, I think your lordship doesn't need to. Whether the individual, does your lordship have that? Whether the individual propagates his personal view or the tenets for which an institution that he is part of and represents is really immaterial for the purposes of Article 25. It is the propagation of the belief that is protected, no matter whether the propagation takes place in a church, monastery, temple, or parlor meeting. So therefore, 25(1), when it says persons, means individuals. Persons could have meant more than an individual, but it doesn't.
They raise the question of corporate body or not.
That's right. And rejected it, saying that no, Matadipati, no doubt, is the head of an institution, but under 25(1), he is exercising his personal rights. And his personal rights doesn't mean that only he believes in it. He may be exercising those personal rights because his denomination believes in it. So this is also, my lord, something which your lordship will keep in mind my lord, when you come to, my lord, the interplay of 25 and 26.
His right to propagate religion
Yes,
is protected.
Protected. All persons being individuals under 25.
And Matadipati as an individual.
As an individual, he is propagating.
That's the issue there.
Correct. Now, the converse of it was also, my lord, noticed in Shirur Mat, that the institution exercises its rights through 26. So, my lord, let us not, my lord, get confused about, my lord, the interplay as to who a person is. 25 is the individual right, 26 is the institutional right. Now, the importance is, and there Mr. Khambata had made this point, that the first and most important thing is the individual. If the individual doesn't have a right, then no institution will have that right. Because what has to be protected is the individual. It may be protected through an institution, but the institution is not something higher than an individual. In other words, if an individual doesn't have that right under 25(1), it is not going to be there in an institution also. Well, I'll develop that in a few minutes. So therefore, I now come, my lord, to the question as to what is protected, therefore, under 25(1) and 26. Please note, my lord, 25(2) does not protect, it protects religious rights, but it is not a right by itself. The state's power to legislate is not an actual right of any individual. Now, when we are doing this, my lord, only one other thing, my lord. I have already defined all persons. The next phrase is equally entitled. My lord, here also I believe, my lord, there should be no confusion. Equally entitled means everybody has a right. Nobody's right is higher than anybody else's right. Let's put it in the negative. Nobody's right is higher than somebody's right, but they're not the same rights. I have a right X. She has a right Y. I'm not somehow higher than her, nor is she higher than me. Important because At the time of the constitution being framed, there were people who contended that for caste reasons or whatever reasons, their rights were more important than other people's rights. So the constitution makers felt that every citizen must be equalized completely in the matter of exercise of this right. Equally entitled simply means this, nothing more, nothing less. Now,
It
Right.
also, Mr. Gupta, it also negates a conscience
yes,
which says that my right or my religious conscience is higher than others.
yes, correct. Absolutely.
That-
Nobody's right or conscience is higher than
because
anybody.
I may have a conscience of superiority
Yes,
and a belief that my religion is better than other religion.
correct, Milord.
The constitutional scheme actually abjures that.
Abjures it. And Milord, it abjures it not on an abstract basis. This is a lived reality of that time. There were people who were prepared to say, I am more important than him, so therefore my right should be protected, his rights is subordinate to me. Now, Milord, having said that, I now come to, Milord, what is protected under 25.1 and 26, not 25.2. 25.2 is something else. Focus, Milord, let us focus on 25.1. Then I will only add that whatever is 25.1 is also 26b. In other words, Milord, whatever is a religious right protected for the individual is the same as the matter of religion protected for the institution. One is not higher than the other. And Milord, that subject to, Milord, which is creating some confusion, will just vanish, Milord, once your Lordship looks at it this way. Now see, Milord. So, Milord, here we have a unique kind of right given to citizens, where if everybody tries to exercise whatever they wish to do, there will be conflict. Milord, anti-discrimination doesn't, Milord, harm anybody. Everybody can be equated. Nobody gets anything. There is no conflict. The rights under Article 19, there is no conflict between two persons, two citizens. Under 21, there is no conflict between two citizens. Both can exercise the same right without stepping on each other's toe. But 25 and 26, Milord, the nature of religion is such, the nature of religious practices is such, it is possible that one person exercising his right legitimately will step on the toes of another person exercising his rights legitimately. This is an intrinsic attribute of, Milord, religious rights. They will come in conflict. Now, to decide what will happen, Milord, if a conflict arises, I'm approaching the question this way, Milord, that if a conflict arises, then how will you resolve it? It will come to court. It will come to court, Milord. In fact, Milord, your Lordships have gone to the extent of saying it is our duty to resolve such conflicts. I'll come to that, Milord, when I make a submission on the court's powers or the court's jurisdictions. But if a conflict arises between two rights put forward by two persons, in that event, Milord, how will this problem be resolved? Only for that purpose was, Milord, the test of essential religious practice devised by this Honorable Court. Because it was faced with conflict. And when faced with conflict, it said, we can only protect what is essential. Then, Milord, so that there is no heartburn on this issue, they said that what is essential, you will tell me. I won't tell you. You will decide, your religion will decide what is essential to you. I will only take evidence and say that this is, I am satisfied that all Muslims believe that this is an essential practice of their religion. Now, in order to, Milord, demonstrate this, Milord, I am taking two instances, no hypothetical things, Milord. These are two cases, Milord, where this conflict is raised and decided. First of all is, my lord, there are, my lord, in a sense, my lord, all cases have something of this kind or not. I'm just choosing, my lord, two. One is Muhammad Hanif Qureshi versus State of Bihar. A legislation was brought banning cow slaughter. The writ petitioner said, cow slaughter is a part of my religious right as a Muslim. So, by banning cow slaughter, you have entrenched upon my right under Article 25. And therefore strike down that legislation. Now we have to find an answer. The answer given was, after looking at the evidence, that even though it is a practice, it is not an essential practice. Why is it essential to slaughter cows? It is enough to sacrifice, say, goats. I'm just giving an example. This problem arises even, my lord, in Hindu religious practices. Because in certain temples, my lord, animal sacrifice is still today prevalent. In many, my lord, in many places, let us say in Bengal, for a very long time, animal sacrifice was part of the worship of Kali. Even today, sometimes it may be done. They sacrifice goats or whatever. But in a majority of situations, it has been now replaced by sacrificing a vegetable. So, my lord, there are these possible practices. How are you going to, my lord, narrow it down? You say that this is essential, this is not essential. This I can protect, this I won't protect. That's, my lord, how essential practices comes in. Second example, my lord. My lord, please don't mind, I'm taking two examples from the same religion. There are such examples, my lord, in every religion. In the first Ram Janmabhoomi case, my lord, Ismail Farooqi, Muhammad Ismail Farooqi. As an interim measure, my lord, after, my lord, the demolition of the mosque, as an interim measure, the government sought to acquire that land. When they acquired the land, my lord, one of the objections which I think Mr. Garg took, Mr. R.K. Garg, was that I have a right to worship in that place. If you acquire that place, then you step on my rights, religious rights. Answer given was that unless and until that spot is so important to the religion that if you take it away, you take away the religion, acquisition of property is not an essential, the need to worship in that particular spot is, or in every spot, is not an essential practice. But there are two very, very interesting situations, my lord, which are not, of course, there in that case. One is, my lord, Parasnath Hill. In Parasnath Hill, my lord, the whole hill is sacred to the Jains. Parasnath Hill, my lord, in Rajmahal district of, my lord, Bihar now, Jharkhand now. The whole of the hill is, my lord, sacred. In the High Court, a case had arisen where some part was being acquired, and the question was, can you acquire any part of the hill? And the courts, my lord, applied this test and said, this particular, it's not as if every little bit is essential. Where there are various installations, those are essential. Didn't come to the Supreme Court, that particular view. This question, it to some extent even arises and has never been resolved in the Kamakhya temple. Because in the Kamakhya temple also, which is on a hill, the belief is of many people that the whole hill is sacred. These are not, my lord, questions which have been adjudicated. I'm just saying that sometimes a particular land is so important to a religion. Let us say the Golden Temple. Let us say, my lord, Makkah. These are so important to the religion that you cannot acquire it, because if you acquire it, you are touching the religion itself. But everywhere else, where you're not actually touching the religion, there, my lord, it is not an essential practice that you must. So, my lord, this is the kind of conflict which comes to court and has to be resolved. And when, my lord, it has to be resolved, the essential practice test is what your lordships, my lord, devised for that purpose. Now, your lordships have felt at point from time to time that are we now trying to decide something which the Constitution doesn't have? The Constitution doesn't say essential practice. So why should we be reading something into the Constitution which is not otherwise there? Now, my lord, there is a very felicitous line in Puttuswamy, which is not, my lord, in my note, but, my lord, it is in para 260, where it was argued that this right to privacy, you're adding to the Constitution, you're legislating, etc. The judgment says that what we are doing is interpreting existing rights. Naturally, my lord, Article 21. We are interpreting existing rights, understanding the core of that right to define the ambit of what the right comprehends. Paragraph 260 of Puttuswamy. So it is a question of interpretation only. You have to, my lord, interpret the right to religion. You can interpret it to say essential religious practices are protected. It's a question of interpretation, certainly within your lordship's domain, and has been therefore followed for all these years, not an addition to the Constitution.
Who is to adjudicate whether it is essential or not?
Yes.
How can the court adjudicate?
My lord, that is the next proposition. But since your lordship is raising it, I give the answer, not the details. I'll go to the details in a few minutes. If the question arises as to whether something is an essential religious practice or not, the court adjudicates it by taking evidence from, my lord, the members of the religion. Court does not substitute its own opinion. My lord, please don't consider this on the same wavelength as judicial review of religious practices. If something, my lord, is violating, let us say, the right of equality, and your lordship say that therefore we will not allow you to practice that, then in the exercise of judicial review, you may be contradicting a religious practice. But this one is not that. Essential, yes.
You would be meaning to say
Yes.
that the duty of the court
Yes.
is akin to the proof of a custom or usage.
Quite right. Quite right. It's a proof of custom and usage which courts do all the time. Here also is a custom and usage. You have to choose a essential, whether it is essential or not. How will you do it?
Say anything which is secular is different from religion.
Different.
Even the Article 25(2) says,
Yes.
any secular activity
Yes.
associated with a religious practice.
Right.
So therefore the state can
Here I'm-
legislate.
Yes.
It's easy to identify a secular activity.
Well-
All others are religion.
Millard, while completely agreeing with you and being grateful for you raising that point, I should only give this caveat that it is not so easy. And has been, Millard, commented upon as being not easy by your lordships.
In Sirur Mat, the question was how much money had to be spent to buy certain articles for the Paryayam once
Yes.
in 2 years.
Yes.
Whether it was necessary to spend so much money or not.
Yes. Yes. No.
Whether to spend money, so much of money for that once in 2 years Paryayam taking over.
Yes. Yes.
Whether it was a religious practice.
Or is it secular?
Paryayam is a religious practice.
Lordship.
Now, anything associated, suppose so much of ghee is required
Yes.
for having a havan at that time.
Yes.
Now, you can't say buying of ghee
Yes.
is secular.
No.
That is what the test
It can't say that it is religious.
But
Buying of ghee is not religious.
no, but then how much of ghee has to be added in the havan?
So, Millard,
Part of religion.
yes,
It
Millard.
is not secular.
No,
For which expenditure has to
No, Millard, buying ghee is religious.
from which market you buy is a different issue.
That's right.
But you can't say you can't buy ghee.
I agree. If the agamas say that 10 grams of ghee is to be used, no question of going into whether 10 grams should be used or not. I agree with that. But, and also, Millard, and this is very important, the question which your lordship has raised. When we are talking about distinguishing between secular religious practices and secular activity associated therewith, the question of essential religious practice really does not arise. Really doesn't arise. Essential religious practice arises only when it is in fact a religious practice. There is some confusion in the judgments on this.
The religious practice, why go again into another classification of essential?
Yes, because, my lord, when two people claim two different rights which clash, you have to resolve.
So that is as against the state.
Not against the state.
See, in Sirurmat, it was as against the state.
Yes.
We are not now between two individuals of the same denomination questioning it. Sirurmat and all these cases are against the state action
Yes.
or legislation.
But that does not mean there were secular actions. My lord, state action can also be violative of Article 25(1) without going into, my lord, 25(2)(a) and B. Simply because it is encroaching upon the religious freedom.
This 25(2) power exceeds, then it will violate either 25(1) or 26.
That's correct. Even if we don't have a 25(2) logic here, even then you can have a state legislation which has encroached. Now,
The answer is to
Yes.
what extent the state can encroach
yes,
is in 25(2).
no. First of all, my lord, suppose it is an essential religious practice. I'm just,
Mr. Gupta,
Yes.
it can also have an individual to individual impact.
it does.
If, let us say, a religion
Yes.
practices
Yes.
slavery or practices human trafficking as a part of religion.
Lordship.
So 23, which can impact an individual,
Yes.
will be in conflict with 26 and
It
may
will-
not be a state action.
It will be, my lord. And there are many other things one can think of where there can simply be a state violating 25(1). If 25(2)(a) or 2(b) is there, then it is solved because those two subsections give the state the power to override the religious practice. But suppose it is not covered by either of those two, even then the question will arise, has the state overstepped its limits and taken away somebody's religious right?
For example,
Even in the absence of Article 25(2),
Yes,
whether the 25(1) is violated or not can
is
be
the
seen.
question. Yes, correct. Now, what I'm trying to get at is this.
It is against the state.
Maybe against the state, but maybe also, my lord, under certain circumstances, in respect of two individuals who are coming to clash. Sometimes, my lord, the state takes up the cause of one of the individuals. I am sure, my lord, in fact, there are some passages to suggest that the cow slaughter ban was because, my lord, there were people who were offended by cow slaughter. That is, somebody's religious right was being protected by the state. While protecting the individual right of the state, the question was, has the state entrenched upon somebody else's religious right? So the reason why they needed to find a test is because everybody's right cannot be protected. You cannot at the same time protect somebody's right to slaughter cows and at the same time protect the right of the person who is offended by the slaughter of cows. Not possible. So therefore, a test has to be found. A principle has to be found by which you will decide. And this principle, your lordship said, was essentiality. And there is no problem, my lord, in determining essentiality. It is determined by taking evidence from members of the same religion, just like you would do in the case of customs or usage generally. I will, my lord, give the details of that submission in 2 minutes. Next, it is not true that this test is not to be found in Shirur-Mat. There are 2 passages in Shirur-Mat which discusses essential religious practice. And these 2, my lord, one is in, my lord, it's a little jumbled up, but please see paras 43 and 35 of my note, my lord, so that your lordship understands, my lord, what I mean by saying that it was in fact discussed in Shirur-Mat. 43 said, my lord, at page 15 of the note, in the first place, what constitutes the essential part of a religion is primarily to be ascertained with reference to the doctrines of that religion itself. Now, if if Shirur Math did not want to discuss essential religious practices, it would not have bothered to say what is an essential part of a religion. This is, my lord, I have given the reference there, my lord, in paragraph 43. Secondly, my lord, in paragraph 35, I have extracted another passage from Shirur Math, which says, under Article 26B, a religious denomination or organization enjoys complete autonomy in the matter of deciding as to what rites and ceremonies.
Where is it? Which page?
Page 35 is at page 13.
Page 13.
Yes. Under Article 26B, a religious denomination or organization enjoys complete autonomy in the matter of deciding as to what rites and ceremonies are essential according to the tenets of the religion they hold, and no outside authority has jurisdiction to interfere with their decision in such matters. In Adi Shaiva, my lord, this it was sought to be argued that this outside authority includes courts. But, my lord, obviously, my lord, Justice Gogoi said, we will be failing in our duty if we do not adjudicate. And so, therefore, outside authority in Shirur Math never meant courts. It meant somebody who is outside the religion. So, these two passages in Shirur Math shows that Shirur Math was, in fact, thinking in terms of essential religious practices. What Dargah committee did thereafter was to elaborate it. So, my lord, the argument that Dargah committee and subsequent judgments introduced this concept and that it was contrary to Shirur Math, my lord, is not correct in my respectful submission.
So, Mr. Jaydeep,
Yes.
Page 15, para 43.
Yes, ma'am.
What constitutes the essential part of a religion is primarily to be ascertained with reference to the doctrines of that religion itself.
Correct.
Per se, as a principle, it is totally correct. Then the most difficult part is, how do you find out with reference to the doctrines of the religion itself? Does the
Yes.
court get into what is the doctrine?
Yes. I will show that. I'll show you, your lordship.
No, no, but how does the court then again?
By taking evidence. Just by taking evidence. Just by taking expert evidence.
Who is an expert? For me, somebody says, I am the expert. And the court,
Well, the parties will decide. Well, the parties before the court will say that this man is an expert, please listen to him.
Shirur Math made this observation, which is not quite, quite unnecessary and unwarranted.
Sorry,
Simple things, it was dealing with, say, case whether it fall under
The amount that had to
25
be spent.
to A or not. As simple as that, it was seen whether it is a secular.
That's not a problem. Well, this distinction between this test of essential religious practice, only because of conflict, even in 25(1).
Only two situations.
Yes.
No unanimity. Has there been unanimity?
There are only two parameters, 25.
Yes.
District order morality and part 3. If it is there, if that is violated, obviously state can.
Then the religious
So
practice. No, my lord.
Then it's only.
I have not made myself understood, my lord. Morality, public health, and public order and health will override a religious practice.
In a case where,
Right.
who's going to determine that?
Yes.
Supposing.
You will decide.
Yeah, that's good. The state, no, state is entitled to decide that.
Not necessarily.
Okay. Not necessarily, but we are only saying,
Yes.
or even an individual who is affected can bring to the notice.
But whatever it is, my lord.
Second, the public morality.
Whatever.
Extent.
My lord.
It is prohibited.
All right.
Prohibited, no problem.
All right, my lord, no difficulty.
Yes, yes.
What that does
This test of essentiality is quite unwarranted by.
No, in that context of that dispute,
Yes.
that the money he had already one lakh
That
of
was
debt.
not the only dispute.
No, there was 1 lakh of debt.
My lord, the entire statute was.
See, the statute was to be imposed. There was a challenge to the action taken by the province of Madras government.
Several sections.
Patadipati. Then several sections of that statute were
Not just
challenged.
ghee, my lord, not just ghee.
No, several sections of the statute were challenged.
Yes, correct.
Question was whether the whatever is required to be spent or arrangement or etc. to be done. Because in the context of that, they said, Paryayam, you require all this. It is a essential religious practice. For that, once in 2 years,
Just to
ashram,
show-
therefore it is in that context.
Yeah, yes, it is.
Every case you have to have an.
They emphasize it because there is some there will be thin line will be there. In order to emphasize this religious practice, they say it's essential.
No, no,
It is not that they categorize it essential or non-essential religious practice.
Will
There are only two categories under 25, we tell you. Yes, that's correct. Secular and religious. In so far as secular is concerned, they say, if it is purely secular, no problem. But even assuming with this being secular, if it is associated with that, even then power is available to this.
Milord,
To this
no. Milord, it's not so, Milord. Just for 1 minute, Milord, 25
You
two.
can't import something into 25 which is not there.
Of course, your lordship can.
Yes.
If you can import privacy into Article 21 as a matter of interpretation, you can certainly, Milord, have an essential religious test if it is necessary. Milord, surely, Milord, if it is not necessary, no.
On that, we'll hear you on the constitutional morality or basic church or whatever it may be.
No, Milord.
Yes.
I'm sorry, Milord.
Just, see, that
I have to, Milord, get
that is-
across the point.
That is to only to understand.
No.
There's no question of causes omission in the
No,
constitution.
no, there is no question of causes.
Yes.
Causes omission.
To just to understand the provision, then you can say, all right, whether you call it constitutional
Milord,
morality.
Milord, there is a concept.
Ethos, whatever the principle you can say,
Ah.
to that extent we can understand. We can, for that purpose, we can go with the preamble and other tools
No.
to understand this.
Milord, that's not what I'm saying.
Yes.
That's not what I'm saying. Religious practice. Suppose something is a religious practice. Suppose something is. Not essential, is. If all these questions of whether it can be overridden will have to be based on morality, public order, etc. It can be based on constitutional morality if your lordship agrees with that, etc. When you do that, you overrule an existing legal practice. Your legal practice is not to allow entry. You legislate under 25(2)(b) to allow entry. When you do that, what is admittedly a religious practice is overridden by something permitted by the law. If it is secular practice, then it is not religious practice at all.
Yes.
So we don't go into the essential religious practice test in order to decide whether something is secular or religious. But if there are two religious practices which come into conflict under 25(1), then you have to have a test.
Whose instance the conflict is important.
It will be
See, a
state will step in.
believer who is
State
not
will step in.
concerned, he can't.
Suppose state steps in.
Then we will examine as to whether it will fall within the mischief of 25(1) or 2.
Milord, I am not arguing Sabarimala.
No, what is the?
I am not arguing Sabarimala.
Now, what is the juridical basis on which we will decide the essential practice or not?
Juridical basis is Article 25(1). 25(1), you find that two people are putting forward two practices which are conflicting with each other.
Who are the two people is important also.
Two people, two individuals, two citizens, both of whom have rights under 25(1).
No, that is- But the question is, see, you must have some kind of a locus to question another religious.
My locus is 25(1) itself.
Another religious practice,
Yes,
a person belonging to a.
because it is conflicting with mine.
That is a.
In exercising your right to do X, you are stepping on my right to do Y.
The court will become a catalytic agent for dividing the society.
Yes.
Milord, the society is not divided by court. The division is arising because of religious practice. You have to solve that divide. You cannot solve the divide without Milord a principle.
Therefore, the first question is, who is coming to the court? The threshold question must be answered first.
Milord, again, Milord, I am not arguing Sabarimala. If two persons with locus standi come before your lordship, then what will happen?
So whether they are believers of that faith.
Of course they are believers. Suppose two believers come before you.
Then why will they question if they are believers?
Because it is stepping on their Milord right.
No, you
That's
can't, because
contradictory.
they believe in that.
They believe it.
The other person also believes in something conflict.
Gupta, please tell us.
Yes, yes.
In Article 25, the mechanism which you are saying, where do you find in Article 25(1)?
Yes.
Please let us understand. You are trying to import something which is not there in Article 25.
Look, this is a-
That is what you are saying.
You need a principle.
We'll understand, we'll tell you.
You will interpret
We'll make it
25(1). Yes.
What you are asking us is to decide a dispute raised by a member of a religious denomination
Yes.
over the denomination, on the premise that he has got a right under 25(1), and therefore you have to decide the article 25(1) right under on this guy vis-a-vis the religious denomination. How, where do you get it in this?
I'm not talking about that. I'm only confining myself to 25(1).
Only we are saying.
Your lordship is bringing in 26B.
No.
All right, then religious denomination is,
Forget about denomination.
yes, forget about it.
Let's say
Two individuals.
Yeah, you see, yes, right. Denomination comes after that.
That comes after.
Mr. Gupta, in all
Actually, the problem comes because of that. Otherwise, there's no problem. If you want to practice something, no problem.
Right.
Nobody is going to stop
in
you.
all probability,
You want to say that others should not practice like this because I wanted to be like this way.
No. Milord, he is showing that it is a religious practice.
Yes.
In Milord, the Hanif Qureshi matter, it was demonstrated that cow slaughter is one practice of the religion.
Just correct. But the other side says contrary to that.
Other side has persuaded the state to ban that practice. Now, should it, when a person comes and says, this is my religion, why are you banning it? We have to find an answer.
Mr. Gupta, there's a slight difference. Animal slaughter may be an essential factor in that religion, but cow slaughter can be.
That is exactly what is held. But Milord, the person who came to court said, no, cow slaughter is the practice.
That is why it has not been.
Correct, Milord. So, in order to find that out, the essentiality test was applied. It was said that it may be essential to sacrifice, but it is not essential to sacrifice cows. Exactly as you said.
Mr. Gupta, in all probability,
yes, Milord.
you are laboring on the doctrine of proportionality when we test two rights against one another.
Milord, why would I labor with a point which has not yet been decided in this court when I have a concept which has been applied for 75 years? Why do we have to go to proportionality? I am saying that there is a conflict which can arise under 25(1). That conflict has to be resolved by courts. When you are resolving it, you need a principle. The principle is essential religious practice. And that is a principle which has been
Why I
applied.
say this?
You are testing. Sorry, Milord?
Why I say this?
Yes.
This is a principle, although not using the generic word of proportionality.
Lordship.
Devaru applied when it tested a legislation
Yes.
against religious practice.
Milord, it is
Balanced it out.
No, Milord, Devaru didn't. I'm going to show you, Lordship, Milord, what Devaru did. Devaru, Milord, 4 steps. Very simple.
I'll let you.
Milord, it's one of the most brilliant judgments of this court, Milord. 4 steps. No shortcuts. Devaru is a religious denomination. Agreed. That religious denomination has a practice that Gaur Saraswat Brahmins only should enter, nobody else should enter. Temple Entry Act said everybody should be allowed to enter. So that is violating the religious practice directly. Question is, 25(2)B legislation is conflicting with a religious right in 26B. Both are co-equal rights. That also is a finding. One does not prevail over the other. Therefore, how are we to solve it? We solve it by applying the principle of harmonious interpretation of statutes. Milord, I'm sorry, Milord, this word harmonization has been used a little too much here.
This harmonious interpretation actually matures into the proportionality test.
But Milord,
that in God's order such temples, entry is permitted, but the manner of worship is integral and
no, Milord, that's not, that is step number 5. Step number 4 is whenever two statutory provisions conflict with each other and they are co-equal, then you apply the principle of harmonious interpretation, which means that you try to give effect to both in preference over an interpretation which takes away one and only keeps the other. This is a principle of interpretation acknowledged for centuries. Applied in Devaru to two co-equal rights. When two co-equal rights come into conflict, you can't say one goes over the other. When you can't do that, you have to apply the principle of harmonious interpretation. Namely that if I give effect to 26B in its entirety, 25(2)B vanishes. If on the other hand, to the limited extent of temple entry, I give effect to 25(2)B, then all rights under 26B remain except one right, that is temple entry. The right to stop people from entering.
That is how the essential test or integral test evolves.
No, my lord, it is not the essentiality test. It is just the principle of harmonious interpretation, as my lord defined in books on interpretation of law, statutes.
There were no two contradictory rights as such in Devaru. Question was whether they could assert that right exclusively against the state law. So the state law was there with regard to temple entry.
Yes, yes.
And then these people.
No, my lord, I am
state
answering.
law not to be applied.
My lord, I am answering Devaru because my lord raised it. Devaru is not dependent on essential religious practice. Essential religious practice arises only if there are two conflicting rights
Yes.
put forward under 25(1) by two different parties. Whether the state gets involved or not is not important.
But in Sirurmat and in Devaru, it was all against the state, not against a private individual.
My lord,
All against the state.
why? All right, very well, it was against the state. But what was the petitioner saying? Petitioner was saying, this is my religious right. How then to sustain the legislation? If it is his religious right, then the state cannot trample on it.
Question was whether it is a matter of religion or not.
My lord,
And how far under 25(2)B the state could proceed.
no.
That was the question.
No. Yes.
Under which provision of the constitution that the act was, rule was introduced in Devaru?
Which rule?
Under 25(2)B?
Yes.
Yes, statute.
The only issue for 25(2)B is
Yes.
whether there exists a social welfare or a social reform.
No.
That's what 25(2)B says.
No, second part.
So the court can not say.
Second part, my lord.
Court can, that is correct. Second part is there.
Yeah.
The court can only satisfy whether that exists or not, whether the state has correctly passed the legislation by invoking 25(2)B or not.
No, that's not the question in Devaru at all, my lord.
Yes.
I'm very sorry.
No, we are telling you, the power of judicial review in this, once the power is exercised, you have to test the powers, that's all.
My lord, you will test the power, my lord. There is no challenge, my lord, to the section. The question is, it was conflicting with 26B right.
It has to give in, because
Which one?
When you say,
Yes.
see, actually it is in the favor of the respondent only we are saying. When you say for the social welfare and then we say social reform, it takes precedent to any other right. When you say 25(1) is circumscribed by public order morality, when you gives the power to the state to invoke 25(2)B, the parameters are much higher, though restricted, as SG said. It cannot be invoked for all and sundry cases. You have to satisfy and then why you are invoking, because it involves the social welfare.
No, my lord.
There
is second part.
We tell you, in that.
I'm sorry, my lord, there is no test.
We tell you, in that, there is no need for the essentiality test, because, as rightly said, obviously it involves religion. You have to confine only to.
Yeah, we should not, my lord, be
Yes.
taking two different concepts
Yes.
and, my lord, mixing them up. Please see, my lord, there is a second part to 25(2)B. It says, throwing open of Hindu religious.
correct.
That was in the
That's
second
correct.
part.
That's the second part.
So this part was satisfied by the legislation.
Yes.
The argument was, in satisfying this legislation, you have entrenched upon 26.
I will tell you,
Yes.
only test should have been, in that case,
Yes.
whether there exists a Hindu institution, religious institution or
Yeah.
not. Number one, it has to be there. There's no dispute on that. Then, whether it has got a public character or not. That's
No, my lord, there's a third test.
If the existence of if it's
There is a
public
third
character,
question.
that's a matter.
My lord, there is a third question.
Yes.
Did they have the right under 26B?
That is what we are telling you, that
Sir, I'll read the judgment to you, Lord.
No problem. We are telling you.
Provisions of the act, they are pre-constitution act.
Yes, sir.
Which one?
In Venkatramana Devaru also, the
No,
Madras Province Act
No, my lord.
is a pre-constitution act.
but it gains strength from 26 to B.
This court when the constitution was enforced. It's a pre-constitution act. Matter arose out of a suit.
Yes, my lord. Followed by a writ petition. Because when this constitution came in, we take it that 26 when there is a right at 26 to B is there. One cannot invoke 25 to B, right? My lord, that is the argument there. We are telling you. Yes. How it will not work out is that. Yes. It 25 to B otherwise will be otherwise applicable to anybody under 25. As you rightly said, it is individual centric or person centric. If they form a religious denomination, then it may not apply to them. Milord, that's not the question in there. No, I'm only telling if you test it. Milord, you can test it. You can test it with that argument if it was arising. An element of absurdity we are saying. It can't be like that way. Milord. Yes. All right. Anyway, I'll Milord, if your lordship permits, Milord, I'll continue tomorrow.
How much time you need?
Milord, I thought, Milord, I want to move on from this, Milord. I'll let it be. So then, Milord, I may take, Milord, about 45 minutes tomorrow. Maximum 1 hour, Milord, no more than 1 hour.
45 minutes.
What you're concluding now, despite our interventions.
Milord, there are 7 questions, Milord. You should say 9. And in fact, Milord, the more difficult question, this is not a difficult question. Milord, your lordships, once you read, Milord, Devaru, you will understand, Milord, that it's not a difficult question. The really difficult question in this matter is, Milord, the definition of religious denomination. It's a difficult question. And that's where, Milord, your lordships will see whether the approach taken by you so far should remain or it should be something else. And both are possible, Milord.
Our problem is that I have scheduled one more matter to be taken up. How, say maximum 1 hour you want,
Maximum.
How much time, Dr. Menka?
1 hour.
1 hour.
1 hour.
My lord, I'll take half an hour.
45 minutes for me.
And only half an hour for me, my lord.
My lord, this is all subject to your lordship's questions, my lord. That's-
See. Now let's be very frank. Only because there were so many questions coming from the bench side to the respondent side that while sitting, I didn't in the morning itself put any caveat yesterday or today that your timeline is this much. And in this process, the respondent side has gained more time than what we granted to the review petitioners already. Now we are
not. But only thing is, Milord, I'm not asking for equality in this field.
It was like, it was almost like 2 test matches, my lords, that they played 9 days.
Not
anyway, my lord, whatever your lordship wishes, my lord, we are not
internationals, my lord.
We are not going to, my lord, argue on this.
Tuesday,
Yeah.
now because on Tuesday only we'll be able to meet.
Yes.
So Tuesday, 1 hour will.
1 hour. That's definitely. No.
Try, Dr. Menka,
1 hour.
45 minutes.
We'll all,
Half an hour.
all together will conclude on Tuesday.
20 minutes, half an hour, 10 minutes and 10-15 minutes. And 10 minutes each. 10 minutes each.
We have the right to reply.
Yes.
Very weighty arguments have been made on the other side.
Very weighty arguments we will have to respond with.
Yes, deeply obliged.
Milord, many of these arguments, Dr. Rajiv Dhawan has made many times.
Grant rejoinder, but briefly.
Yes. If you are holding Mr. Gupta.
Then the amicus.
My lord,
Just has to argue. Amicus.
Yes,
I hope
Mr. Prameshwar and both of you will just sum up after the rejoinder is over. After the rejoinder is over, and your exercise is only to sum up both the sides.
Sir, know that you won't be drowned by all this.
Honorable Chief Justice, sir, I would like to also have a little time on to conclude. I have about half an hour, sir.
lighter note, if I may say.
Very,
Yes, Mr.
sir.
There's a famous
About half an hour, sir. Half an hour should
On a
be.
lighter note, if I may say, there's a famous quotation that I've seen far.
As far as the ladies are concerned, we will be liberal. We will grant you time. If you ask for 5 minutes, we'll grant you 5 minutes.
Your lordship, if I may mention a fresh matter, my lords, to be listed.
Thank you, sir.
Not repeat, my lords.